Additional Chief Judicial Magistrate Borpeta had convicted the petitioner for a period of 6 months rigorous imprisonment, and in the default of the fine payment of rupees 4 lakhs, another 3 months of Lordship simple imprisonment. Lordship, the petitioner preferred an appeal before the Session Judge Borpeta, Lordship, and he did not interfere with the said judgment. And Lordship, later on, Lordship, the petitioner surrendered before the Honorable ACJM Borpeta. Lordship, without going into the merits of the case, Lordship, the petitioner has already undergone the rigorous imprisonment of 6 months, Lordship. And Lordship, till date, Lordship, she is behind the bars for 200 days, that is 6 months, 18 days. I have to say, Lordship, that since Lordship, she has already undergone the rigorous imprisonment, Lordship, and she is a poor lady, she won't be able to pay the fine of rupees 4 lakhs. I humbly pray, Lordship, her prayer may be allowed, Lordship, and this simple imprisonment is suspended, Lordship.
Heart, Mr. P.P. Midi. Learned Counsel for a petitioner. First up, this criminal revision petition under Section 442, read with Section 438 of the Bharatiya Nagarik Purikha Honita 2023 is preferred against the judgment an order dated 25/7/2024 passed by the Court of Learned Sessions Judge Borpeta, within bracket Appellate Court, in criminal appeal case number 04 of 2022, whereby the Learned Appellate Court, while dismissing the appeal preferred by the revision petitioner herein, has affirmed the judgments and order dated 19/2/2024, passed by the Court of Learned Additional Chief Judicial Magistrate Borpeta, Trial Court. (19/2 2024) Trial Court. Passed in NI case number 58 of 2018. Post up. The complaint case, by the judgment and order dated 19/2/2024, the trial court had convicted the revision petitioner for the offense under Section 138 of the Negotiable Instrument Act 1881, as amended, and the revision petitioner has been convicted, or has been sentenced to undergo rigorous imprisonment for a period of 6 months and to pay a fine of rupees 4 lakh, in default of payment of fine, to undergo simple imprisonment for another 3 months. Full stop. A revision petition is admitted for hearing. The case records of so-and-so, appeal number so-and-so and NI case number so-and-so be called for, issue notice returnable in 4 weeks. The revision petitioner shall take steps for service of notice upon the sole respondent by registered post with AD as well as by usual process. Release the case after 4 weeks. The NI was that day you show some judgment, right?
Yes, Lordship.
Where is the latest one? That relaxation can be done.
Yes, Lordship.
Show me. Supreme Court. Heart, Mr. P.P. Methi, learned counsel for the applicant revision petitioner. Post of the instant interlocutory application is preferred by the applicant revision petitioner seeking suspension of execution of the sentence passed against her and for her release on bail. Post of the applicant as a revision petitioner has preferred the accompanying criminal revision petition number 237 of 2025 against the judgment in order that is so appellate court in para. The complaint case, NI case number 58 of 2018 was instituted by the respondent, opposite party respondent, herein as the complainant, alleging commission of the offense under section 138 of the NI Act. After dishonor of a check amounting to rupees 2,10,000 issued by the applicant revision petitioner on an account maintained by her at State Bank of India, Borpeta, Bajar branch. Full stop. Para. It has been averred that the applicant revision petitioner was produced before the trial court on 22/1/2025 in execution of a non-bailable warrant of arrest NBWA issued against her by the trial court. Full stop. On being so produced on 22/1/2025, the applicant revision petitioner was committed to the district jail Borpeta to serve out the sentence passed by the trial court and upheld by the appellate court. Post of. As on date, the petitioner, applicant revision petitioners period of custody is how many days?
Till date to Lordship, 200 days, Lordship, 6 months,
200
18 days.
Post of. In other words, the applicant, that's revision petitioner, has served the substantive sentence of 6 months. Post of. Yes, give me.
Okay. Lordship, para 25, Lordship. 20. Which is the intention of the legislature.
No, there is Supreme Court judgment. I asked for you. You don't do the research.
Lordship, in Jambudri,
Itu INFC itu চাই ল'ব in Jambu Bandari versus MP State Industrial Development Corporation Limited and others. এটা ক্রিমিনাল appeal নাম্বারটো দি ব্ৰেকেটত দি দিব। The Honorable Supreme Court of India has observed that in a case where the appellate court is satisfied that a condition of deposit of 20% will be unjust, or condition of deposit of 20% provided in section 148 of the Act, will be unjust, or imposing such a condition will amount to deprivation of the right of appeal of the appellant, exception can be made for the reasons specifically recorded. Full stop. When an appellate court considers the prayer under section 389 Code of Criminal Procedure 1973 within bracket presently, section 430 Bharatiya Nagarik Surakha Sanhita bracket close of an accused who has been convicted for the offense under section 138 of the Act, it is always open for the appellate court to consider whether it is an exceptional case which warrants grant of suspension of sentence without imposing the condition of deposit of 20% of the fine stroke compensation amount. Full stop. If the appellate court comes to the conclusion that it is an exceptional case, the reasons for coming to the said conclusion must be recorded. Full stop. Para. It is ordinarily, if a person faces incarceration in default after making default in payment of fine, such a convicted person pays the fine imposed in order to obviate, in order to avoid incarceration, full stop. Where having regard to the fact situation obtaining in the case, comma, as narrated above, comma, this court finds that the case in hand is one where an exception can be made. Post up. Accordingly, it is ordered that pending disposal of the accompanying criminal revision petition, which has already been admitted today, comma, the remaining part of the sentence passed against the applicant revision petitioner shall remain suspended till the disposal of the accompanying criminal revision petition number so and so, and the applicant revision petitioner shall be allowed to, is to be allowed to go on bail of rupees 10,000 with one surety of the like amount to the satisfaction of the land trial court. Full stop. With the above observations and direction, the instant interlocutory application is disposed of.
I'm deeply obliged to you.
Item 2.
Go to the final of the posted folder. Custody. Very good. Reason to be able to delegate video transfer. Yes.
Notion regarding the Jima last occasion, call for a report that was placed before.
It was placed in the record, madam.
Now, where is the coal?
Coleman.
Where is the coal? Where it is kept?
There, inside the truck.
Inside the truck. So
Yes.
truck is there.
Yes, Lord.
Where is the previous order? What was the previous order?
Yes.
Where is Mr. Sama? Where is the
No.
provision in BNSS for search and seizure? Any idea?
My lord, in the record,
No, no.
last time, my lord.
BNSS.
Man.
Provisions for search and seizure.
Yes.
It is here.
Earlier CRPC is 100, I think. No, no, that is
503.
Mm.
BNSS.
Mm.
And what is the equivalent provision of 451?
503, my lord.
497, actually, it is regarding the magistrate power. Order of custody of the disposal property pending trial or in certain cases. 497.
Hmm. Yes. Then P2. Order for
Suppose this is released, interim custody is provided, what should be the condition? Because it could be a matter of evidence also.
Madam.
Under what condition? Under what condition? Because it is not that
Permissible because they submit the bond, Lordship.
Right.
That amount of,
bond amount, that is a different thing.
yes, Lordship.
But it is a matter of evidence also.
It is matter of, because.
It is a matter of this
that-
coal, seized coal.
Provides regarding the order of custody of disposal of property pending
No,
trial. in certain
madam, it
cases.
is not that.
They will take photograph and submit the same to before the London magistrate.
You were saying that this is already inside the track.
Yes,
Is it not?
yes.
Okay. Yes, mister. How
Yes.
to do it?
My lord,
We have to keep an inventory or Panchnama.
yes, my lord.
Is it not?
Yes. And my lord,
There is a provision. That is why I am asking you.
yes. So my lord,
In the new BNSS,
new marriages, my lord. Yes, but it is my lord 503, my lord.
503,
Three.
right?
Then, my lord, two, subsection two. Subsection two, my lord, said, my lord, magistrate may order the property to be delivered to him on such condition, if any,
Right. that
as
is
the
condition.
magistrate thinks it fit,
That is condition.
my lord.
And 53-ton coal is not that it is to be kept, it is to be sold,
My lord,
right, by the person entitled to possession.
yes.
But that how the evidence is to be retained.
And my lord, another is, my lord, 497. BNSS. Disposal of property.
505 also lordship power to
No, that
sell
is not-
imperishable property.
Madam, you are not understanding my question. That is regarding sale of perishable property.
Yes, Lord. That is perishable.
You are not understanding my question.
Mhm.
If it is the photographs
Mhm.
of the coal, payment of the coal are not recorded, it is delivered,
Mm.
then no evidence will be left,
No evidence left.
right?
Inventory. Or-
Inventory,
Yes.
there is some provision I have
Yes.
seen somewhere, but I am not very accustomed with BNSS. That is a problem. That is why I have been asking you.
Yes.
They mentioned in the seizure list, lordship, about the quantity of coal.
Yes, my lord, the 597, my lord, 3. It is written, the court or the magistrate shall cause to be taken the photograph.
Para,
Photograph.
page.
497, my lord, sub para 3, my lord. Videography also, my lord, that is mentioned, my lord. The court or the magistrate shall cause to be taken the photograph and if necessary, the videograph on mobile phone or any electronic media of the property referred in subsection 1.
Subsection 2 also. That
Yes,
is
ma'am.
what.
Yes, ma'am. In 2 also.
Court or the magistrate shall,
Right.
within a period of 14 days from the production of the
Yes.
property referred to in subsection 1,
Mm.
there is a production, right?
Yes.
Basically says, for example, currency notes, ganja or
Mm.
whatever,
Madam.
which can be produced.
Madam.
Now 503 is such property is not produced
Yes.
before a criminal code,
Madam.
right? Truck is not taken inside the code.
Mm.
Truck with the coal is not taken inside the coal. There are these are the two difference.
Mm-hmm.
451 and 457. Here it is 497 and 503.
503.
Some things are taken and brought before the magistrate.
Mm.
Some things are not taken to the magistrate.
Mm.
Suppose the coal, it is not taken to the
Mm.
magistrate
Mm.
in the premises of his office that he comes out and looks at that coal.
Mm.
It is produced through the seizure list.
Mm.
So there 457 is applicable.
Mm.
If say bundle of currency notes,
Yes, yes.
451 is applicable, meaning thereby 497.
Mm.
Heart. Miss M. Dib, learned counsel for the petitioner. And Mr. B. Sharma, learned additional public prosecutor for the respondent number 1, State of Assam. Full stop. Uh, 28/7/2025 order to Sawaha. Para 2. Three, 4, 5. Repeat করে দিব. When the this petition was listed on 28/7/2025, comma, learned additional public prosecutor had placed a report, correction dated 24/7/2025 of the IO, as called for by the order dated 16/7/2025. In the IO, also in the report, the IO stated that the case has been investigated and thereafter, a charge sheet, right, charge sheet number 278/2025 has been submitted against the apprehended accused persons on 29/6/2025. Poster. The report has report further mentioned that despite giving ample opportunities with regard to the time the driver and the helper failed to produce any valid legal documents in support of the coal being transported through the subject vehicle. Poster. There was no reflection in the order dated 6/6/2025 that the IO had verified the documents submitted by the petitioner with regard to its claim of ownership for the seized coal weighing 53 MTS. First, the impugn order dated 6/6/2025 is found to have been passed without any observation on the documents submitted by the petitioner in support of his claim of ownership for a seized coal weighing 53 MTS within bracket approx. Poster. In the report dated 24/7/2025, there was also no reflection that the IO had considered the documents which the petitioner has relied upon as regards his claim for ownership in this criminal petition, annexing those as Annexa 1 to Annexa 11. Full stop. In such backdrop, the petitioner was allowed to submit the aforestated documents before the IO. In such context, by order dated 28/7/2025, the petitioner was allowed to submit the aforestated documents before the IO on or before 1/8/2025. Also, it was further observed that on submission of the aforestated documents, the IO should send a fresh report on or before 7/8/2025 after verification of those documents, to the learned additional public prosecutor. Post of para. A report dated 7/8/2025 of the IO from Jurabad outpost under Bukhisto police station, addressed to the public prosecutor Guwahati High Court, in connection with Bukhisto police station, case number 188/2025 has been placed before this court. Post of para. in the report dated 7/8/2025, the IO has inter alia reported that the subject vehicle, along with 53 MTS within bracket approx of coal, was seized in connection with Bokhista Police Station case number 188/2025. Post of the IO has further stated that the seized coal weighing 53 MTS within bracket approx would not be required for further investigation, as the case has already been charge sheeted by charge sheet number 278/2025 on 29/6/2025. Full stop. The IO has further mentioned that in deference to the order dated 28/7/2025, the petitioner had submitted relevant documents such as e-way bill, tax invoice, authorization certificate, etc., pertaining to its claim of ownership of the seized coal. Full stop. It is further reported that upon verification of those documents, it appears that the petitioner is the registered, is the owner of the seized coal weighing 53 MTS approx loaded in the subject vehicle. First of all, the IO has pointed out that no such documents were earlier produced by the petitioner at the time when the subject vehicle was intercepted or during the course of investigation to establish ownership of the seized coal. It has been further mentioned that in view of the case being charge sheeted and upon verification of the ownership documents submitted in deference to the order dated 28/7/2025, the seized coal weighing 53 MTS approx can be released in interim custody. Post up. Para. In chapter XX P1 permanent 36 of the BNSS 2023. Put in bracket R here. Chapter 34 Roman, in the Code of Criminal Procedures 1973 has provided for titled Disposal of Property. Has enumerated the provisions for disposal of property pending investigation, inquiry, or trial, and also at the conclusion of a trial. Post of the provisions of section 497 and Section 503 of the BNSS, which are perimeter to Section 451 and Section 457 of the Code. Read as under. Section 503 of the BNSS deals with the powers of the magistrate to pass orders as to the disposal of the property seized during the course of inquiry or trial, but not produced before the court. Where is your seizure list? Seizure list,
And actually 49 page,
page
49 page.
in the case of Sundarbhai Ambalal Desai versus the state of Gujarat, 2002 10 SSC, the Honorable Supreme Court has considered the situation which has emerged due to non-exercise of powers vested in the jurisdictional magistrates. Under Section 451 and Section 457 of the Code, which resulted into which resulted which resulted, full stop. It considered the situation of keeping seized articles at various police stations. Full stop. To overcome such situations, and to avoid misappropriation or tampering of the records at the police station, Honorable Supreme Court issued a set of directions so that the burden of the courts as well as at the police stations can be reduced to some extent, and that there may not be any scope for misappropriation or of replacement of valuable articles by spurious articles. Full stop. The Honorable Supreme Court has laid down the course to be followed in the following manner. Para 10, 11, 12, 13, 14, 15, 16, 17. 18. 21. Yes, Mr. Sharma, what is the condition? Details.
But my lord, videography,
The Miss Dave Lanet, counsel for the petition, has submitted that the interim custody of the subject vehicle has already been granted in favor of the petitioner by an order dated 28/7/2025 by this court in criminal revision petition number 260/2025.
That petitioner is different.
This is not
259
in-
petitioner is
in favor of the registered owner
owner of the vehicle.
of the subject vehicle by an order dated so and so, passed in criminal revision petition number 260/2025,
Till today it has.
subject to the conditions mentioned therein, right?
Till today, that is not.
Don't
No, Lordship, I am just. informed.
don't be impatient. MSDM has further submitted that the seized coal weighing 53 MTS, within bracket, approx, involved herein, is kept loaded in the subject vehicle. Full stop. In view of such situation, both the seized coal of 53 MTS approx involved herein and the subject vehicle are still kept at the police station.
Yes,
Full stop. And despite the order dated 28/7/2025, the subject vehicle, the interim custody of the subject vehicle has not yet been handed over to the registered owner of the subject vehicle, right?
yes, Lord.
as the petitioner seems as on the basis of the documents annexed at Annexer 1 to Annexer 11 to this petition, the petitioner seems to be entitled to the possession of the seized coal weighing 53 MTS approx, the seized coal, the of weighing so and so, is to be released in favor interim custody. Of this is to be given to the petitioner subject to compliance of five zero 497 subject to compliance is to be given, full stop. Is to be given subject to compliance, full stop. Before handing over interim custody of the seized coal, the jurisdiction magistrate shall prepare a statement of such property containing its description in such form. Description. And shall cause shall take the photographs and if necessary, videograph on mobile phone or any electronic media of the property of the seized coal. Full stop. The statement so prepared and a photograph or a videography taken shall be used as evidence in any inquiry, trial, or other proceedings under the BNSS. Full stop. The photographs of such of the property so released should be attested or countersigned by the petitioner, by the IO, the accused persons, as well as the petitioner to whom the interim custody is handed over. So it is further observed that the actual production of the seized coal approx so and so during the trial should not be insisted upon, and the photographs along with the panchnamas should be treated as sufficient for the purpose of evidence. Full stop. Any valuation?
Whole is the amount, 4 lakhs,
Hmm?
4 lakhs.
4 lakh.
Yes.
Where from you say?
I asked.
Let us see your document, GST document. E-way bill.
You build an actual whole,
Where is that page for?
say 36 solution.
Page 36.
Yes. 4,55,000.
Yes, Mr. Sharma. What do you say?
Value of goods, lordship,
I've seen.
4,55,270.
My lord. And the bond of reflecting that amount, my lord. And our document of ownership.
Hmm?
Well, already submitted before
Yes.
the.
Hmm. The petitioner, the interim, the custody of the siege court is to be given to the petitioner, provided that the petitioner furnishes an indemnity bond of rupees 4,55,270, which is the value of, what is the weight?
Bill.
Weight is there?
Weight is not.
Not there, may not be the correct.
Caesar list or no?
It is in the
Huh?
Caesar list.
Caesar list.
Seizure list.
Yes.
49 page. And it's a 51 page, it is, that was typed copy. Beda six
Ah.
lordship.
Okay. Which is the value of the said C school reflected in E-way bill number, page 36, dated 6/4/2025. And the seizure list being seizure list, MR number 294/2025. Full stop. Before, the IO should keep all information and documents necessary for identification of the C school after being authenticated by him and the petitioner. Full stop. Out of condition. By setting aside the impine order dated 6/6/2025, the instant criminal revision petition is allowed in the aforestated terms. I may make 1 or 2 correction. I didn't see it. I think it was always a very good time. So it was like a pretty or something like it. Huh? Which is. Yes.
Item three.
May I please your lordship?
Yes.
My lord, in this case, paragraph two, my lord,
Paragraph two.
paragraph two, page five, my lord,
Page.
page five,
Page five.
paragraph two. This
Of petition. Of your petition.
Yes, my lord.
Paragraph two, page five.
The petition is filed before this honorable court, praying for state criminal proceeding of CR case number 17/18 under section 138 NI Act pending in the court of Landed SDA JM Rongia till disposal of the civil suit number 318/18 pending in the court of civil judge senior division number 2.
Why?
My lord,
Where is the law? That is.
well, I am relying on decision also because although both the criminal and civil case may be flowed, but
What is a civil suit? Let us see. Let us see the civil suit. Plaint.
civil suit, my lord. They are same subjects of the
Let
same
us see
issue
first.
between the same parties.
Let us see.
Page
Where is the plaint?
25,
Huh?
Annexa 2,
Page
page 25.
25.
Civil suit prior portion may be, relief portion may be, perished, my lord. Relevant
Which is the
portion,
relief portion? Okay.
page
Chandra
28, my
Kolita.
lord. Relief what?
Okay, Chandra Kolita, he is what? Petitioner. Same.
My lord, I am challenging the
Suit for
original.
declaration damage, suit for declaration, damage, compensation, along with consequential relief.
My lord,
Suit
page
is the
28 is the
plaintiff
relief
is a
portion, my lord.
permanent resident. Defendant is Rohingya town. Plaintiff Zoid is an employee of the working divisional railway manager, Rohingya. Okay. Defendant is a powerful person. Defendant made the with his group of two unknown antisocial elements in Rohingya to sign. With this one they started trading him. Forced and demanded illegal money, frequently visiting the working place, giving various troubles. Defendant with his group repeatedly approached the plaintiff of his working place, visited his house, demanded the illegal money as commission with threatening. To finish and damage his life and job by filing false complaint claim against him before him. The hate motive his group closely took from the plaintiff as illegal money defined by approaching him using personal treatment him. Even they have regular treatment, so and so. But even in collision, his group of friends harassed the petitioner and demanded illegal money, depending on his rate with related plans or about demanded illegal money trading. His division pay something nature. Something other than in course. There is not. Visited. Okay, forcefully took the sick.
Sex, my lord.
Okay, good.
Prior portion may be finished. Page
No. Now, after that, on 25/8/2016, they forcefully took a check.
Yes, my lord.
Did you lodge any FIR?
FIR was not filed. Is a
When this suit was instituted?
suit instituted
2018. When? At what time?
immediately after serving
Month.
the notice.
August.
Yeah, 2018.
Okay, where is the complaint now?
Complaint, my lord, page number 43.
Page
Annexa 8,
number
my lord.
43. Some okay, son of a-
Subject matter is land sale agreement, my lord. Regarding land sale agreement, which is the first fabricated documents. Complaint itself, paragraph 2 stated. And this petitioner, accused person also shown there is a member
Receive the total amount.
of the tribunal, railway tribunal,
Thereafter,
but he is a government employee only.
more mobile to not. And he has referred to an agreement for
What?
sale of land.
My lord, Annexer 9, PS 50 may be perused, my lord.
Hmm.
This has been suppressed in the complaint petition. Why suppressed? His own advocate notice was, legal notice was served, but this is suppressed. So entire matter involves regarding a land sale agreement deed, not the check money, my lord. Annexer 9 PS 50 may be perused. Clear statement of the own complainant himself, who is suppressed in the complaint petition. By suppressing this notice, my lord, legal notice,
Which one notice? Which notice?
PS 50, my lord.
Hmm.
Five zero 50, my lord. Annexer 9, PS 5050.
Hmm. Hmm. Yes.
This notice filed, my lord,
By, on behalf of Sankordi.
Sankordev
Ah,
filed,
that was in 6/6/2017.
yes, my lord.
Right.
Alleging the land sale agreement transaction,
Ah.
there's no regarding not its regarding check money.
Ah.
My lord, this notice is wiped after this may be period 6/6/17 notice was served. No complaint was filed. Any why? No complaint was filed. No any suit for speech performance was also filed. But subsequently 2018 he filing a complaint case, my lord.
He
So
gave a
this
story.
notice is wiped already.
He gave a story.
My lord, this is the issue, my lord, regarding land sale agreement
Ah.
between the same party, who is challenged in the civil suit,
Ah.
declaration that this agreement land agreement is null and void, false fabricated. So, paragraph, Your Honor,
There is no bar.
civil suit is not bar, and the criminal also not. That means
There is no bar.
But my lord, question is this.
Because all the provisions
now-
contained in NI Act,
PS 42, my lord, may be perused. PS 42, Annexer 7, my petition, my lord.
Annexer,
Annexer 7, PS 42, 42, my lord.
huh,
In the civil case, it is already going to be disposed because evidence of plaintiff side already closed, but and defendant's evidence already filed, and they are going to be closed, and defendant complainant evidence already closed examined. Now evidence of DW 2 and 3 also remained only. So for your lordship will find 42, page number 42, TS suite are going to be completed now. So at this stage, why your lordship, the petitioner compelled to express, because the two parallel proceeding is going to be disposed in this. But in complaint case, evidence not already filed, not cross-examined. But in civil case, it's going to be restored within shortly, my lord. Because evidence already defendants filed only left to cross examination. So some time is required. Because to save the judgment of civil court, my lord, before giving a judgment of criminal court, within short, this I date your lordship to further proceeding of the criminal case. Only 2 or 3 months. Waiting till disposal of the civil suit, my lord. If my civil suit decides the entire matter, so there will be the binding judgment of the order of the civil court will be binding the criminal court regarding transaction, money, and regarding agreement, whether it is genuine agreement or sell it. So regarding this, I have also, my lord, decide one decision to save the embracement of both the suits. Ground have taken, my lord. This parallel suit should be considered, my lord, because civil suit is the decides the matter.
Anything? There is no bar.
That is no bar, but civil.
No bar.
The honorable
And
court has
the case projected is different.
I am.
Case projected is different. I'm dismissing it.
Temporarily.
I'm dismissing it. There is no bar. Law is not that.
The inherent jurisdiction of the honorable court.
It is not. There is section 210 CRPC regarding FIR or complaint case, but not regarding civil case.
It is the only fair before your lordship just to state the further facility in this civil suit, which is going to be disposed immediately, my lord. In this regard, my lord, I have ground number 6, case 16, my lord. It is the provision of law. There is also that stay of penal proceedings.
Ground number 16.
Ground number 6, case 16, my lord. Why this prayer south, my lord? This may be proved. Case 16, ground number 6, my lord. The stay of penal proceeding pending disposal of the civil suit can be granted
No.
while it is necessary to avoid.
No. This cannot be. There is compliance. Where is the complaint? Where is the complaint?
Complaint, my lord, annexer 8, page 43.
What is this judgment, page 20? Page 20, what is this judgment?
Judgment session Rongia, my lord. I filed the petition.
Oh, you have been already
Rejected.
tested to forum. Tested to forum, I think.
Rejected by the learned session judge. Prayer was rejected. Without, with actually petition was filed, my lord. My petition
Yes,
is not
are you a
discussed on
party?
merit, my lord.
Are you a party? You should have said first that I had approached the trial court, thereafter the revisional court,
Revisional.
and this is the third attempt
Yes, my lord.
in the third forum. You should
question
have
is-
said that
My submission, your lordship will.
and correctly and properly recorded.
Petition was filed by
Heard,
the
Mr. B. Hussain. There is no bar. Oh, let us. I'll come back. No bar. Under section 4438, read with section 442 of the Bharatiya Nagorik Puraikha Hanita 2023 is preferred seeking stay stroke suspension of the criminal proceedings of a complaint case, CR case number 17/2018, presently pending before the Court of Lanit Subdivision Judicial Magistrate within bracket M, Rongia Trial Court, to disposal of a civil suit, title suit number 318/2018, pending before the Court of Lanit Civil Judge within bracket Senior Division number 2, Kamrup Metro at Guwahati Civil Court, between the same parties on the ground that the two proceedings are on the same subject matter and the question of genuineness of a document, namely, an agreement for sale of land is the foundation of the civil suit as well as the criminal proceedings. Full stop. Para. The respondent herein, as the complainant, has instituted the complaint case, CR case number 17/2018, before the trial court on the ground that two checks amounting to rupees 10,000 and 5,000 issued on 10/5/2018, respectively issued on 10/5/2018 by the petitioner from an account maintained at Allahabad Bank, Rongia Dongpar branch, Rongia, stood dishonored on its presentation from collection by the complainant. Full stop. In the complaint, the complainant has stated that when he presented the two checks for collection at his account maintained at UCO Bank, Rongia branch, the same were returned unpaid on the ground of insufficiency of fund. Full stop. A demand notice was thereafter issued to the petitioner on 15/6/2018, calling upon the petitioner to pay the check amount within a period of 15 days from the date of receipt of the said notice. First of the complainant has asserted that the said demand notice was duly served upon the petitioner on 18/6/2018. First of, when the petitioner failed to pay the check amount of rupees 15 lakhs pertaining to the dishonored check within a period of 15 days, the cause of action for filing the complaint under Section 138 of the NI Act as amended arose on 3/7/2018. That is after expiry of 15 days from the date of service of the notice. Full stop. The trial court took cognizance of the offense on the complaint for the offense under Section 138 NI Act and issued process for appearance of the petitioner to stand in trial as an accused. Full stop. Para. In the course of the proceedings of CR case number NI case number 17/2018, the petitioner as accused filed a petition, petition number 207/2021 with a prayer to stay the proceedings of NI case number so and so as a civil suit, title suit number 318/2018 in respect of same subject matter is pending between the parties between the civil court. Full stop. The trial court, after hearing both the sides, by an order dated 28/11/2022, rejected the prayer made in petition number 207/2021. Full stop. The trial court, in its order, has observed that there is no bar in proceeding with a criminal case, even if a civil suit is pending between the same parties. Full stop. The trial court has observed that the complaint case, NI case number 17/2018 has arisen out of region of checks and can only be adjudicated in the proceedings undertaken by the complainant by filing a complaint. Full stop. The trial court has further observed that there is neither any procedure for stay of the proceedings of NI case number so and so, nor any anomaly in the proceedings of the same. Full stop. And hence there is no scope for allowing the prayer of the petitioner as the accused made in petition number 207 dated 25/1/2021. Full stop. Para. Agreed by the order dated 28/11/2022, the petitioner carried the matter before the Revisional Court of Learned Additional Sessions Judge Rongia, Wide Criminal Revision number 02/2023. Full stop. The Revisional Court will लिखिबो bracket out. After hearing both the sides, before the Revisional Court, the petitioner had renewed his prayer for stay and placed reliance in a judgment of this court in it was not relied there. Okay. In criminal petition number 446/2021, within bracket, Pranab Judy Dutta versus Chief Branch Manager, SBI. Full stop. The revisional court, after considering the submissions of the parties and taking note of the ratio laid down in the judgment relied on, came to a finding that the case under the NI Act stands on a different footing. As it provides for punishment and fine. Vis-a-vis the civil suit, which provides for no punishment as a remedy in civil nature. Full stop. The revisional court did not find any infirmity in the order dated 28/11/2022 and did not find any ground to interfere with the said order. Full stop. Resultantly, the revision petition has been dismissed by judgment dated 12/12/2024. Full stop. Being dissatisfied, being aggrieved by and dissatisfied with the judgment dated 12/12/2024, the instant revision petition has been preferred. Full stop. Para. Mr. Hussain, learned counsel for the petition, has contended that the civil suit, title suit number so and so is at the advanced stage, as it is fixed for
Close up DW's only.
cross-examination of
DW's, my lord.
DW, wherein the petitioner herein is the plaintiff. Full stop. He has submitted that the civil suit is going to be disposed of immediately after cross-examination of the defendant's witnesses. And if the criminal proceedings in NI case number so and so is not stayed, suspended, there will be multiplicity of the proceeding and would be conflicting observations of the two courts. Full stop. He has further referred to a decision of this court in Ofas Sondode versus Durga Shah, reported in 1989, 1 ZLR 78. Full stop. Para. The civil suit, title suit number so and so has been instituted seeking a declaration that the alleged deed of agreement for sale of land dated 29/12/2015, prepared by the defendant therein, that is the complainant, in NI case number so and so, is false, fabricated, collusive, illegal, null and void, inoperative law, and not binding upon the plaintiff. And also for a declaration that there was no such agreement or legally enforceable debt or liability on the part of the plaintiff. Full stop. In the plaint, the plaintiff had alleged that the two checks were obtained by the defendant along with a group of antisocial elements. Post para. In Abhas Chandra De Supra. It has this court has observed that in an appropriate case, an order to suspend stay of criminal proceedings can be made to avoid multiplicity of proceedings. Post. The court has further observed that there is no doubt that criminal proceedings should be expeditiously decided and may not ordinarily be stayed. Post. It is only in an exceptional case come an order for suspension stay should be passed. Post. Reverting back to the facts of the case in hand, it is noticed that the complainant in NI case number so and so had served a legal notice upon the petitioner on 6/6/2017 asserting that an agreement for sale of land was executed on 27/8/2015 for sale of the landed property mentioned therein Full stop.
Malay agreement shown on 29/12/15.
29, 12,
29/12/15.
29, 12, 2015. Full stop. It was informed that as per the said agreement for sale of land, the petitioner showed a location of the landed property within Rongia Municipality Corporation, Rongia Ward number 7, Gurukuchi Road. But as per the land revenue records, the landed property was actually situated within the periphery of Dokhin Sitara village. Full stop. By the said notice, the petition was put on notice to register the landed property by preparing a sale deed in favor of the complainant within a month, or else, the complainant would be bound to file a suit before the concerned court. Full stop. Para. In the complaint of NI case number so and so, the complainant had alleged that when the petitioner did not, refuse to hand over the possession of the landed property for which the agreement for sale of land was made, the complainant came to learn that he was deceived by the petitioner and he immediately asked the petitioner to return the amount he had advanced as he had paid as advance consideration against the landed property. Full stop. Para. It is a settled law, settled proposition that mere institution of civil proceedings is not a ground for quashing of a criminal proceeding, or to hold that the dispute is merely a civil dispute. Full stop. The provisions contained in the NI Act as amended are still contained, and the assertions made in the complaint of NI case number so and so apparently fulfills the requirement for filing of the complaint. Full stop. The power of quashing a complaint or FIR should be exercised sparingly with circumspection, and while exercising the inherent power, this power, the court must believe the averments and allegations in a complaint to be true and correct. Save in exceptional cases where non-interference would result in miscarriage of justice. Full stop. Para. Having regard to the events enumerated above and the subject matter of the two lists in the form of title suit number so-and-so and NI case number so-and-so. This court is of a considered view that there is no infirmity in the reasoning assigned by the trial court in its order dated 28/11/2022 and the revisional court in its judgment dated 12/12/2024. Full stop. This revision petition is also barred by limitation. After 90 days, this court does not find any reason not to much less good and sufficient reason, to stay, suspend the proceedings of NI case number so-and-so, merely for the reason that the proceedings in title suit number so-and-so is pending before the civil court. Full stop. A limitation. The instant revision petition is preferred. Criminal revision petition is preferred on 6 August to assail the judgment dated 12/12/2024. Full stop. As per Article 131 of the limitation 1963, a revision petition is to be petition for revision of an order under the Code of Criminal Procedure is to be heard within a period of 90 days. Full stop. Para. In view of the above discussion, in the light of the above discussion, and for the reasons assigned herein, this criminal revision petition is found not merited, and accordingly the same is dismissed.
Item 4. We have, due to have personal difficulties, item will be taken up in next week.
On the prayer of Mr.
SK Chetri.
SK Chetri, Land Council petition, lays the case in the next week.
Item number 5.
Yes, sir.
My lord, the petitioner, my lord, before this criminal revision,
Hmm?
my lord, under the
Criminal
enactment. of the
appeal,
petition-
criminal appeal,
My lord,
CR case, enact,
my lord, my lord.
convicted,
Convicted, my lord, convicted.
undergo simple imprisonment to pay compensation. How much? 4,26,000
26.
by the trial court. Then
Trial
what did the appellate court do?
My lord,
No
the
interference,
conviction was upheld and my lord, criminal appeal was dismissed, my lord.
dismissed. No interference with the sentence.
No interference, my lord.
Upon analyzing so and so, finding. So, on
At
what
least,
ground?
Notice may be issued, my lord, and record may be called for. Otherwise, my lord, what is the, in fact, in the course of proceeding before the trial court, my lord, the petitioner examined one witness, my lord, as DW1. In his, my lord, evidence, he clearly stated that actually the transaction took place with the husband of the complainant. Husband of the complainant and my lord, prison petitioner, they are colleague, my lord, working in the same railway department. And my lord, 1,20,000 was received from the husband of the complainant. Against that amount, my lord, total 5 number of blank check were issued as security check. When the money was repaid, my lord, that those security check were not, my lord, returned, my lord.
Do
Then-
concurrent finding of facts, sir. Two courts.
Still, my lord, the revisional code also, my lord,
What is the illegality?
illegality, my lord,
Findings of fact cannot be gone into.
but the some legal aspect also that cannot be that can be taken into, my lord, the
You
only
can
thing-
issue notice only.
notice and record may be called.
Heard Mr. M.A. Islam, learned counsel for the petitioner, and Mr. B. Sharma, learned additional public prosecutor for the respondent number 2, State of Assam, the instant criminal revision petition under so and so 442, लिख दियो, लिखा है पास title so and so is preferred to assess a judgment and order dated 8/7/2025 passed by the Court of Learned Sessions Judge, Kamrup Metro, Guwahati.
My lord, it was wrongly written as criminal revision in
Okay,
page
okay,
3 of
criminal
my-
appeal
criminal
number
appeal, my lord.
59
Yes, my lord.
of 2024, page 13 also. Appellate court will issue. Whereby the appellate court, while dismissing the criminal appeal prepared by the petitioner hearing, has dismissed or has affirmed the judgment and order dated
Page number 25, my lord.
5/4/2024
4.
of conviction and sentence passed by the Court of Learned Judicial Magistrate, First Class, number 3, Kamrup Metro, Guwahati, in a complaint case, CR case number 5001 of 2017. Full stop. The trial court has convicted the petitioner for the offense under section 138 of the Negotiable Instrument Act 1881 as amended, and he has been sentenced to undergo simple imprisonment for 6 months and to pay a compensation of rupees 4,26,000 to the complainant.
And in default, my lord, 2 months assignment, simple imprisonment.
In default to make payment of the compensation amount, to undergo simple imprisonment for another
2 months.
2 months. Issue notice returnable in 4 weeks, as Mr. Sharma has appeared accepted. No formal notice. The petitioner shall take steps for service of notice upon the respondent number 1 by registered post secretary as well as by usual process within 3 working days from today.
But so far my instruction is concerned, my lord, there is a possibility of settlement also during pendency of the revision before this court, my lord. At this stage, my lord, the imperial order may be stayed, my lord.
No, then,
trial court, my lord.
you don't
my lord,
make the last line. I was waiting for it.
And my lord, record may be
Then subject to deposit of 50%.
notice, my lord.
We have the discretion up minimum 20%.
My lord, I'll take a step, my lord. I'll take a step, my lord.
Huh?
I'll take steps for notice, my lord.
If you
Item-
deposit 20% registry, I'll stay the remaining part. Otherwise, no.
All right. All right.
Item 6.
My lord, we have challenged the employment order that is page 23, my lord. In this case, lordship, the learned court issued an NBWA against me and PNA also. My case is this, my lord, in FIR, my name is not there. Some persons who were arrested, they're disclosed my name. So on the basis of the statement of
Where is
co-accused,
the FIR?
is 10.
Page 10. Okay. Seizure of fancy dial. Okay. Then case was registered under which provision? 468,
That is
471.
That is interesting.
Good enough. Then when it was surseated,
It is seated
It is. That's it.
31/5/2010.
2010.
Notes.
Surseated was submitted against how many person?
It is annexed.
It was submitted against 6, 7, 8 persons, 9 persons, my lord.
9 persons.
Yes. And my name appears at page 18, Rajesh Purua. So
You
these
were
are-
at top of the list.
No, top of the list. means I-
Rajesh Borua.
Among the arrested and thereafter forwarded. In the
Arrested,
top of the list,
forwarded.
accused Ajit Singh.
Where is your bail order? Earlier?
Bail order, my lord, I have not annexed, but it is there, my lord. Kindly see page 18, accused, arrested and forwarded. So thereafter forwarded, I was released on bail. That
When?
I have mentioned in my
Mentioned?
petition,
Let me see.
para 3, page 4 of my petition.
Para 3.
Now, my lord, my only limited prayer is this. As I was earlier arrested on the basis of the statement of the co-accused.
Oh, no, we are not going into the merit.
No.
We are only NBWA. Right.
Yes.
We are not going into merit.
Yes, yes. I am only for that. I am ready to appear before the learned trial court, but I am afraid of that if I appear, I may be sent to custody. As earlier, I was granted bail, and when someone was received by my family members, at that time I was in Kerala for work. So now I have come. I am ready to appear before the learned trial court.
Page
My only prayer is this.
21, Lordship.
Page
21, Lordship. First.
Yes, page 21.
Yes, ma'am. 21 first PNA issued, my lord,
Mhm.
against Rajesh Borua, my lord. And Lordship will find, my lord, in the middle portion, my lord. Record reflects the summons have been continuously issued to him.
Issued.
Yes, ma'am. From the date things are seated, but without any fruitful result, considering the long
So without
pending
any fruitful result, but
Yes.
someone has been
issued.
sent to the correct address or not,
Yes.
that is not mentioned.
Not reflected.
Not,
reflected.
right.
Yes. And your lordship will find in the last order also, my lord, that is
According to reasoning, warrant, what is it?
PN, again, my lord, fresh PNA issue.
Hmm.
Page 33, man.
That anytime he fails to appear, the summons is proved to have been. Okay, and what about the other persons? Not traceability, all are
Yes,
non-traceable.
yes, my lord.
Then subsequent orders,
Yeah, page 33, the last order, my lord. And the subsequent order, your lordship will find page 28, then again,
issue, call for a date report or
Lots of-
for a.
all are similar orders, my lord. PNA along with NBW.
Then page 33, what is this?
33 is the, my lord, one person that he is been declared a proclaim offender, my lord, one Narendra Singh. And for others, again,
Case is filed.
case is filed, my lord. In page 34, my lord,
Hmm.
case is filed.
Let him appear in the within period of 15 days.
Lordship,
We keep it under suspension.
lordship.
Yes, my lord, that will do, but one prayer, my lord, that on my appearance, Lanet could may grant me bail.
No, that is not there.
We can,
Once it is issued, NBWA PNA, this is a form of anticipatory will, no? That
No,
will
no,
keep
not-
in suspension.
Issuance of summons, that is correct. But whether I have received or not, only one summon was
Then we
received
have
by-
to call for the entire record, we will issue notice. Scan copy.
No, I
If
want
your
to say-
legality is to be tested, we are trying to extend our power that will keep this order under suspension for a period of 15 days so that you are not arrested by police. You appear before the trial court and make an application for bail. It will consider because it will be under suspension.
Some direction.
That is the order I am passing.
yes.
It is up to you.
A little longer time, maybe. I am from Tripura.
15 days is to
Tripura.
15 days is
Let it be 20 days.
15 days. Tripura is hardly by
Preparation
flight
is-
1 hour and 1 night.
Preparation is necessary.
Heart, Mr. M.U. Mahmood, Learned Counsel for the petitioner, and Mr. M.P. Goswami, Learned Additional Public Prosecutor for the respondent state. Poster. The instant petition under section 528, Bharatiya Nagorik Surakha Sanhita 2023 is preferred to sale an order dated 23 to 2023 and other subsequent orders passed by the Court of Learned Additional
CGM.
Chief Judicial Magistrate Kamrup at Amingao within bracket trial court, whereby the trial court has issued non-bailable warrants of arrest against the petitioner as an accused in GR case number as a charge-sheeted accused in GR case number 115/2014 within bracket লিখি দিব GR case number 6517 of 2009 bracket close. Full stop. Para. A first information report was lodged before the officer in charge, Polahbari Police Station, on 29/7/2009 by an assistant sub-inspector of police attached to the same police station addressed to Palapari Police Station in reference to a general diary entry number 827 dated 28/7/2009, full stop. As per the FIR, basing on an information received from a source to the effect that narcotic substances were carrying by a truck bearing registration number NL-08/A-0970 proceeding towards Guwahati, subject vehicle. The subject vehicle was intercepted at an area near Betpusi. Full stop. On a charge being made inside the truck, in presence of witnesses, 73 number of gunny bags were found under rice packets, and each gunny bag found containing 4 number of cartoons. Full stop. Each of the cartoons contained 50 number of fancy dyed bottles. Full stop. The fancy dyed bottles were seized. Full stop. The said FIR was registered as Palakpari Police Station case number 169/2009 under sections 468/471 IPC. Full stop. Where it transpires that after completing investigation, the IO of the case submitted a charge sheet being charge sheet number 112/2010 on 31/5/2010, finding sufficient incriminating materials against how many persons? 8,
6, 3,
again,
9%.
9 number of accused persons, including the petitioner, for committing offenses under section 468/471/34?
It's 34, yes.
34
34 IPC.
IPC. Full stop. Para. After on registration of Palakpari Police Station case number, and during the course of investigation, the petitioner was arrested and thereafter forwarded to the court of law and Chief Judicial Magistrate, Kamrup at Aminggaon. Full stop. On being so produced, he was remanded to custody. Full stop. Subsequently, the petitioner was allowed to go on bail. Full stop. Para. The petitioner has averred that he is originally a resident of Tripura, and after being released on bail, he went back to his native place at Tripura. Full stop. The petitioner has further asserted that after filing of the charge sheet, summons was received from the trial court. Full stop.
When he was at Kerala in work.
During the period between submission of the charge sheet, subsequent to the submission of the charge sheet, the petitioner also went to Kerala for a number of wherein to earn his livelihood, and he stayed in the state of Kerala for a number of years. Full stop. Para. From the order dated 23 to 2023, passed by the trial court, comma, it transfers that summons were issued to six number of suspected accused persons. But on that, till that day, comma, all the six suspected accused persons so summoned, comma, did not appear before the trial court. Full stop. A report was submitted to the effect that one of the accused person, suspected accused person, comma, namely, comma, Ajit Singh, was dead. Full stop. Summons issued to the other five accused, suspected accused persons returned with a report. Oh no, other four persons returned with a report of non-traceability. Full stop. Insofar as the petitioner is concerned, comma, the trial court had recorded that summons issued to him did not return. Full stop. As the records reflected that the summons had been continuously issued to the petitioner from the date of being solicited, comma, 5/8/2010, without any fruitful result, comma, the trial court, taking note of the fact of long pendency of the case at the stage of appearance, comma, deemed it justified to issue proclamation and attachment within bracket P&A, along with non-bailable warrant of arrest against the petitioner. Full stop. By order dated 23 to 2023, comma, the trial court posted the case on 28/4/2023 for appearance, stroke, and for reports on the P&A, stroke, NBWA, full stop. Para, the subsequent orders on subsequent dates, comma, none of the six accused persons were found present, and the trial court ordered for issuance of FRIS, NBWS, and P&A against all of them. Full stop. Subsequent orders, kita likhi dibo. 22 pa date kita ase. Site mein serially. On 12/12/2024, comma, all the six accused persons, namely, naam kita di dibo bol raha ase, were found absent. Full stop. The trial court observed that NBWs and P&A issued against the accused persons did not return an order for issuance of FRIS, NBW, and P&A against them. Full stop. Recording that GR case number 115/2014 is an old pending case and pending since 5/8/2010, comma, the trial court came to has observed that a chance of appearance of the accused persons in a short period is very less. First, the trial court, observing that till receipt of the death report in respect of the deceased accused person and PNA report of the remaining accused persons, including the petitioner, the case be filed until further order. First, para. The provisions for proclamation for person absconding and issue of warrant in lieu of or in addition to summons are contained in section 82 and section 87 of the Code of Criminal Procedure, CRPC or the code. And they read as under. Full stop. Para. In the order dated by the order dated 12/12/2024, command the trial court. Sorry, 12, not 12, bro. Mm. 23/2/2023, the trial court deemed it justified to issue to order issuance of non-bailable warrant of arrest as well as proclamation and attachments against the petitioner. Post up. As per the provisions of section 82, it is only after the court has reason to believe that any person against whom a warrant has been issued by it has absconded or is concealing himself so that such warrant cannot be executed, may publish a written proclamation. Post up. Meaning thereby, it is only after issuance of a warrant of arrest, the steps for issuance of proclamation can be made. Post up. In the subsequent orders also, the same were repeated without any recording any region. Following the provisions of section 82 and section 87 of the code. Full stop. Be that as it may. Full stop. The petitioner has approached this court by undertaking that he is ready and willing to participate in the further proceedings of GR case number so and so by appearing in person and submitting to the jurisdiction of the trial court within a short time. Post up. It is submitted by him. It is submitted on his behalf that in view of the apprehension that he might be taken into custody in execution of the NBWS issued already against him. The petitioner, but he has the apprehension that he might be taken into custody. Post up. He has further submitted that it has been further submitted that if the NBW is issued against him are kept in abeyance for a limited period, the same would facilitate the petitioner They would facilitate the appearance of the petitioner before the trial court. Full stop. Having regard to the fact of non-appearance of the accused persons in the proceedings of GR case number till date and the undertaking made by the petitioner, this court is of the considered view that in the interest of justice, the NBWS issued against the petitioner can be kept for a period, kept in abeyance for a period of 15 days so as to facilitate the petitioner, so that the petitioner can appear before the trial court without the apprehension of being taken into custody in execution of the NBWS already issued against him. Full stop. It is accordingly ordered that the NBWS issued against him shall be shall remain in abeyance for a period of 15 days from today. And if the petitioner appears and submits to the jurisdiction of the trial court within such period of 15 days and submits and prefers an application for bail, the trial court shall consider the bail application on its own merits and in accordance with law. First up, it is made clear that in the event of failure on the part of the petitioner to appear before the trial court within a period of 15 days from today, the NBWS issued against him shall revive.
Chief, I have a humble prayer. Item number 28, the last item. Maybe possible for today. Next.
Okay, on the prayer of so-and-so, learned counsel for the petition, the case is passed over for the day with the consent of learned additional public prosecutor.
And next day, next Tuesday, Lordship, it can.
Tuesday is full. This next week is full already by
Thursday.
different orders.
Thursday?
Thursday also full, many. Third day after that. These are this Thursday. This Thursday.
It is not possible.
This Thursday not
Next
possible.
Thursday.
Next Thursday.
And my interim will continue, Lordship.
Okay, interim.
Highly obliged.
May it please, your Lordship.
Yes.
Lordship here.
GNRC Medisho. Yes.
NI proceedings started against the petitioner.
NI. Enact.
NI Lordship.
Hmm.
And 2000 during COVID period, 21-22. Thereafter on 23, NBW has been issued. Your Lordship admitted default, Lordship. Only prayer before your Lordship that he now willing to participate in the trial proceeding.
Okay.
And therefore, Lordship, the
NI was
NBW.
taken 2021.
Yes, Lordship. I have only annexed the orders, Lordship. The initial inception of the case is page 14. Thereafter, page
Oh.
24 is the NBWA.
Page.
Page 24 is the first NBWA and the subsequent orders,
Okay.
Lordship. And tomorrow is the date fixed, Lordship.
Thank you. Yes, Mr. Goswami.
We are not being made party, my lord.
Okay.
Hmm.
Absent. Petition is absent. You were earlier
I have filed.
absent with step.
Earlier, I was absent with state. Thereafter-
Absent with steps.
Yes. Lordship, thereafter miscommunication with the council. But I'm not going into all those, Lordship, nothing on merit, Lordship, only kind of.
Heard Ms. T. Shom, learned counsel for the petitioner. Post of the instant criminal petition is under so and so 528. Bharatiya Nagarik Surakha Honita 2023 is prepared. Seeking setting aside in quashing and or pen stroke or quashing of an order dated 27/2/2023 and all subsequent orders passed thereafter in the course of proceedings of a complaint case, CR case number 5412/20 to 2021. Pending before the Court of Learned Judicial Magistrate First Class, Kamrup Metro at Guwahati Trial Court. Post up by the order dated 27/2/2023, the trial court recording the absence of the petitioner as the accused in CR case number 412/2021, order for issuance of non-bailable warrant of arrest against the petitioner to secure his appearance in the said proceedings. Post up. As the petitioner was found absent on subsequent dates on 26/3/2023, 7/10/2023, 22/2023, 27/2023. Silo we have page number 24 of CL Saijabo up to 22/4/2023, finding absence of the petitioner in the proceedings either with steps or without steps. Ordered issuance of fresh NBWs against the petitioner. Post up. The proceedings of CR case number so and so was initiated after filing of a complaint by the respondent herein as the complainant, alleging commission of an offense under section 138 of the Negotiable Instrument Act 1881 as amended, post up, on 8/4/2021, the trial court took cognizance of the offense under section 138 an act and issued process to the petitioner as the accused. It should process in the form of summons. Also, on subsequent dates, in the meantime, there was advent of COVID-19 pandemic, which continued for a period. Post up. On 2/4/2022, the trial court issued bailable warrant of arrest against the petitioner. There was no report to the effect that, oh, you have appeared, no? Okay, no, like post up. Para. The petitioner has approached this court by the instant petition submitting that he is ready and willing to participate in the proceedings of CR case number so and so by appearing before the trial court, provided opposed to the petitioner has expressed an apprehension that as the non-bailable warrants of arrest have been have already been issued, comma, he has an apprehension that he would be taken into custody in execution of those NBWS before his appearance before the trial court. It is submitted that if the NBW is already issued against the petition, now which are in currency, comma, are kept in abeyance for a limited period comma, he can appear before trial court and also can submit an application making a prayer for bail. Full stop. It is stated that the next date, it is stated that the next date of the case is on tomorrow,
Tomorrow.
or is on so and so tomorrow. Full stop. The appearance of the petition as the accused in the proceedings of CR case number so and so is necessary for an expeditious conclusion of the proceedings of CR case number so and so. Full stop. As the petitioner has made an undertaking that he is ready and willing to participate in the further proceedings of CR case number so and so, and there will not be any deliberate default on his part henceforth, comma, this court, in the interest of expeditious conclusion of the trial, comma, is of the considered view that the NBWS issued against the petition can be kept in abeyance for a limited period of 10 days so as to enable the petitioner to appear before the trial court without the apprehension of being taken into custody in execution of the NBWS already issued by the trial court against him. Full stop. It is accordingly observed, full stop, the petitioner shall appear before the trial court within a period of 10 days from today, and in the event if upon appearance, comma, the petitioner submits any application for bail, comma, the trial court shall consider such bail application on its own merits and in accordance with law. It is with the above observation and observations, the instant criminal petition is disposed of in the aforesaid terms.
Till such appearance.
Yes, kept in abeyance.
On the problem.
Item 8.
Please, Lordship.
Hmm.
Lordship, I'm appearing on behalf of Mr. A. Kakoti, Lordship.
Okay.
He was present today, but Mr. Kakoti was present today, Lordship, but he got a call from his
Okay.
home, Lordship.
Tell
Due to
me.
some medical emergency, he had to
Okay.
run back.
What is your prayer?
Lordship, my prayer is, Lordship, kindly fix the matter next week. Lordship. Anything next week.
State is a party.
It is a party formal.
What is the case about?
Lordship,
Any idea?
Yes, Lordship. Lordship, we filed a defamatory complaint, Lordship, at JMFC, Kamrup Metro, Lordship.
Defamatory?
Complaint, Lordship. Criminal,
What defamatory?
Lordship, defamation case, Lordship.
Huh?
Lordship, we have filed a defamation case, Lordship, at the JMFC, Kamrup Metro, Lordship.
Huh.
It's against order dated 21/7/25, Lordship. Yes, Lordship. The first hearing was done on 21/7.
Defamation complaint.
Yes, Lordship.
Only the my lord grievance here is, my lord, the date that was given is after 6 months, my lord, a date has been given. That is the exactly their prayer, my lord.
Okay, proviso to section 223, B and S.
Lordship, our only prayer is to prepone the order date, Lordship.
That is a discussion also,
Lord.
but under what section? The complaint is under what section? Complaint 39 Bharatiya Nagorik. Hmm? 356.
That is
The
next.
356. What 356? Naya Honita, okay. Niyaya Honita. Is there any provision somewhere in CRPC or BNSS that proceedings should be completed preferably?
223, my lord, they have.
There is a notice. in
Yes,
the
that
first
is,
proviso.
they have, my lord, there, my lord, regarding that, my lord,
23 subsection 1.
examination,
Hey, criminal rules and practices.
Lord.
Criminal rules and practice. Criminal code. That is too long a date otherwise.
Otherwise, my,
Lordship.
yes,
Is there any provision somewhere?
but that is what I am thinking, my lord. 222 is a prosecution for defamation, my lord.
Defamation.
Yes, but here. Yes, my lord, of course, there is a limitation that within 6 months complaint has to file, my lord. Others, only that within 6 months complaint is to be filed, my lord. That is
That
one.
is 468.
That is one section, my lord, under 222, and otherwise.
Huh?
Have been committed. I think there's a person. Nowadays, my lord, perhaps time. I have to check the provisions, my lord. Otherwise, time, my lord, that will be difficult because again the appearance of accused is before going to the my lord. Taking cognizance, my lord. That takes some time.
If it is 6 months, then
That is
this kind of thing should not be encouraged also.
lordship. That is. Decision.
Yes, what is provided in the
Lordship, our only prayer is.
procedure? Your prayer is there, but on what ground? 6
Lordship,
months, I understand.
Yes.
Now what the law says? Procedural law says that I have to find out. Is it not?
Apologies, Lordship.
Mr. Rusai, find out from
I have to.
General Criminal Rules and Practice Manual.
Lordship, there.
Okay, on the
Yeah.
prayer of Mr.
J. Pegu, Lordship.
J. Pegu, Land Council for the petition, list the case on so and so. Find out.
I'll find out.
20. If you don't come with some research, it is very difficult for us to
Lordship, I came.
sitting in the court to make research.
Lordship, I was at the other court, Lordship, my senior, he just.
20.
20.
Item 9.
Obligation.
Find out which provision normally day-to-day trial otherwise
Lodge.
Lordship.
Lodge.
in the CRPC.
Lodge.
Yes, ma'am.
May I please, your Lordship?
Hmm.
Lordship, in this particular case, the FIR was filed by one Jodumoni Sharma, the principal
Moni Sharma.
and in
Okay.
charge of Ramchandra Burwa Public Higher Secondary School under Jaipur Police Station, under Lakhipur Subdivision of Kachar District, your Lordship. The FIR was filed on 17/2/2017, your Lordship.
Hmm.
We have
Okay.
already annexed the FIR
Huh.
in as along with the written Ejahar in page number 15 to 17 and 18 and onwards, your Lordship.
Hmm.
Your Lordship, the sections provided were sections booked were 448, 468, 420, 471 and 419 of IPC. There are total 20 accused persons, your Lordship.
Here it is 10.
Your Lordship?
Here it is 10, page 19 and 20.
Yes, your Lordship. It is 10, but during the charge sheet provided, it was 20.
Okay, 20.
20 accused persons, your Lordship.
Okay.
Your Lordship, the charge sheet was provided after 7 years, your Lordship.
Hmm.
On 34/2024, your Lordship. And thereafter, SDGM Lakhipur took the cognizance.
Hmm. Which
Lordship.
order? Which order? Cognizance?
My apology, your Lordship, we have not annexed the order.
When cognizance taken? When cognizance taken, any idea?
25/6/2024, your Lordship.
25/6 to 2024.
Yes, your Lordship.
Okay. Yes. And sources submitted?
Yes, your Lordship. After the charge sheet 34/2024, your Lordship.
34/2024. Yes.
Our prayer before this, our prayer before your lordship is, my lord, it is already barred under section 468 of the CRPC.
Why?
Your lordship,
Let us see the FIR.
yes, your lordship.
17/2/2000. I understand not today. HSLC examination. So somebody else appeared as proxy candidate.
Yes, your
That
lordship.
is allegation.
Allegation, your
Well,
lordship.
allegation, until it is established, definitely.
Allegation, your lordship. And someone else was arrested, your lordship.
Okay,
And subsequently.
okay,
his name-
10 persons in place of 10 candidates.
Yes, your lordship.
So you are Azad Hussain.
Azad Hussain.
For you, Samir Ahmed.
Yes, your lordship.
Okay.
Allegedly.
Then
Azad Hussain was.
what is the point of law now? What is the point of law? That period of investigation took 7 years.
Yes, your lordship.
Where is the provision that it has to be investigated and such must be submitted within a period of so and so?
Yes, your lordship.
Where is the provision?
Sir, your lordship.
468.
No, your lordship. 173.
Okay, 173. Let us see 173.
Let me see.
Sure. Hmm. 73. CIBC.
Yes, your lordship.
Which part?
173 clause.
Without unnecessary delay.
Yes, your lordship.
That's all.
And your lordship, according to section 193 BNSS,
190?
3 BNSS,
193 BNSS.
193 clause 9 of the BNSS says that if it is not promptly given, then the special.
BNSS will not come
come at
because
it,
of the reason that the charge was submitted on 34/2024. So let us
On file
keep
to see,
BNSS away.
Yes, your
file to
lordship.
41.
Your lordship, pay for the.
Everything happened, cognizance happened earlier to BNSS.
Yes.
Only thing is that there are 167,
Yes, your lordship.
even if constitution, or even if CRPC is taken, I think 57. Maybe 57.
Four 68. Otherwise,
67 says 60 days, 90 days, default bail.
yes.
Right.
Freed up.
That does not mean that investigation cannot continue.
Yes.
Yes, your lordship, but it is unnecessary delay of 7 years, your lordship. That is.
There is nothing, no provision. On what ground you are challenging?
May I kindly say 468.
468
plus
2B.
no,
B and
2B, man.
2B.
That part there.
B and 2C, your lordship.
2B and 2C. Let us see 468.
Not.
So what is the interpretation of this?
Your lordship, the investigation was carried on and the charge sheet was given after unnecessary delay. That is another part, your lordship. But learned SDJ took cognizance after 7 years. your
Yeah, and
lordship.
we know that Article 21 is there,
Yes, your lordship.
but that is right to
life,
speedy
person and liberty.
and fair trial.
Yes, your lordship.
Trial has not yet started. Right.
Criminal case is pending against them, your lordship, for 7 years.
There is no provision. Unnecessary delay, but that does not mean that we can curtail. (468).
Yes, your
Have
lordship.
you read Sarah Matthew?
No, your lordship.
Have you met Sarah Matthew?
No.
Constitution bench of Supreme Court. iPad joke. iPad to 9. So 17 is the incident.
Lordship.
17 is the FIR.
Yes, your lordship.
The interpretation is that if the offense punishable under 468 ABC, whatever, 6 months, 1 year, and so and so, if the complaint is not filed within that period, then only 468 will come into operation. That is not regarding investigation. Yes, it was carried out longer
No.
than expected, but that cannot be a reason. We have to close this. Wrong interpretation.
Yes, sir.
Heard, mister? Anything?
Lordship. No.
Heard Miss R. D. Gupta, as for learned counsel for the petitioner. And Mr. M.P. Goswami, learned additional public prosecutor for the respondent state of Assam. Full stop. Para this criminal petition under section 528 of the Bharatiya Nagorik Suraksha Sanhita 2023 within bracket previously comma section 482 of the Code of Criminal Procedure 1973 bracket close is preferred, seeking quashing of the proceedings of ZR case number 45 stroke 2017 and police report case within bracket PRC number 153 stroke 2024, comma, which arose out of Jaipur police station case number 04 stroke 2017, comma, and presently pending before the Court of Learned Subdivisional Judicial Magistrate M. Lakhipur, Kachar, Trial Court. Full stop. Para. The facts, comma, relevant for the purpose of the instant criminal petition, comma, can be narrated briefly at first. Full stop. One who is that man?
Jodhumani Sharma.
One Jodhumani Sharma, comma, officer in charge, HSLC Examination Center, Jaipur, Rajabazar, Kachar, as the informant, lodged in as a first information report before the officer in charge, Jaipur Police Station, on 17/2/2017 on the subject, page 18, quote unquote, regarding proxy candidates in the HSLC examination, 2017, in the Jaipur Rajabazar Center, Kasar, unquote. Full stop. Para. In the affair, the informant had inter alia stated that 17th February 2017 was the first day of the higher secondary leaving certificate examination. Full stop. In the course of examination, the supervising, the informant as the supervising officer with the help of the other officials detected as many as 10 candidates who appeared as proxy candidates of 10 HSLC examinees. Full stop. After being detected, the proxy candidates were handed over to police and the FIR was lodged to carry out necessary investigation. In that connection, full stop. The FIR was received and registered as Jaipur Police Station, case number 04/2017 under sections 448, 468, 420, 471, 419 of the Indian Penal Code on 17/2017. Full stop. Para. After registration of the case, investigation was carried out. Full stop. After completion of investigation, a charge sheet under section 173(2) CRPC was submitted by the IO by charge sheet number 08/2024 on 30/04/2024, finding prima facie case against 20 number of accused persons for the offenses, for committing the offenses under sections. What is the end part of the charge sheet? Okay. 448, 468, 420, 471, 419 IPC. Full stop. The petitioner herein is one of the 20 charge-sheeted accused persons. Full stop. Para. It is stated that after submission of the charge sheet, the trial court has taken cognizance on 25/6/2024 and issued processes to the charge-sheeted accused persons for their appearance before it. Full stop. Para. The only contention that has been raised in this criminal petition to assail the criminal proceedings of a TRC, GR case number arose out of so and so, is on the basis of the provisions contained in section 468 CRPC. Full stop. It is contended that after Jaipur Police Station case number 04/2017 was registered on 17/2/2017, comma, the investigating authority took more than 7 years to submit the charge sheet on 30/4/2024. And in view of the provisions contained in section 468, 2C,
See.
comma, the trial court could not have taken cognizance on the said charge sheet on 25/6/2024. Right? Full stop. Para.
Service.
It is contended that the entire proceedings has been time barred. Full stop. Section 468 of the code reads as under. Earlier, regarding interpretation of the provisions contained in section 468 CRPC, there arose a conflict of opinion between a two-judge bench decision of the Honorable Supreme Court of India in Bharat Damodar Kale versus State of Andhra Pradesh. Which is followed in another citation is Hailowa. Two-judge bench decision in Japani Sahu versus Chandrasekhar Mohanty, and a three-judge bench decision in Krishna Pillai versus T. A. Rajendran. Full stop. In Bharat Kale Supra, it was held that for the purpose of computing the period of limitation, comma, the relevant date is the date of filing of the complaint or initiating criminal proceedings and not the date of taking cognizance by a magistrate or issuance of a process by court. Full stop. In Krishna Pillai, comma, it was observed that no court shall take cognizance of any offense. No, the court was concerned with Section 9 of the Child Marriage Restraint Act 1929, which stated that no court shall take cognizance of any offense under the Child Marriage Restraint Act 1929 after the expiry of 1 year from the date on which the offense is alleged to have been committed. Full stop. The three judgments held that since magisterial action in the case before it was beyond the period of 1 year from the date of commission of the offense, the magistrate was not competent to take cognizance when he did in view of the bar under Section 9 of the Child Marriage Restraint Act 1929. Full stop. As a result, a conflict arose apparently on the question whether, for the purpose of computing the period of limitation under Section 468 of the CRPC, in respect of a criminal complaint, the relevant date is the filing of the complaint or the date of institution or prosecution, or whether the relevant date is the date on which a magistrate takes cognizance. Full stop. The following questions arose for consideration before a constitution bench. Before a constitution bench in Sarah Matthew versus Institution of Cardiovascular Diseases, 2014, 2 SSC 62. Para questions kita ase 3.1 or 3.2. Para. Answering the reference, the Constitution bench has observed that if the date on which the complaint is filed is taken to be material, then if the complaint is filed within the period of limitation, there is no question of it being time barred. After thorough examination of the provisions contained in Chapter XXX 36, titled Limitation for Taking Cognizance of Certain Offences in the CRPC. The Constitution bench has observed in the following manner. Has observed following manner. Has observed that for the purpose of computing the period of limitation under Section 468 of the Code, the relevant date is the date of filing of the complaint or the date of institution or prosecution, and not the date on which the magistrate takes cognizance. Full stop. Para. There is no limitation prescribed under the Code of under the code for completing the investigation of an offense and filing of charge sheet before courts. So subsection 171(3) within bracket 1 of the code provides that every investigation shall be completed without unnecessary delay. Full stop. However, section 173 CIPC was amended by Act 5 of 2009, WEF 3112/2009, and a new subsection 1 capital A was added to it. Full stop. As per newly added subsection 1A, comma, the investigation in relation to so and so, likhe dibo. Para. The offenses involved in so and so case number are so and so, 4481, and the charge sheet was submitted for commission of the offense, says under so and so. Or Saramichu pays paragraph 51 to likhe dibo. Para. Having regard to such settled position of law, comma, the grounds urged in this petition is found to be misconceived and bereft of any merit, resultantly, a criminal petition being not merited, comma, is liable to be dismissed, and it is accordingly ordered.
Your Lordship, item number 10 is also based on the same FIR, Your Lordship.
Same thing.
Yes, Your Lordship.
Okay, same order.
Yes, Your Lordship.
Now it is covered case. Item 10 is covered.
Item 10 is covered.
Item 12.
Rabia Khan. Khatun.
May I please, Your Lordship?
Yes, Mr. Khan.
That wife has filed a complaint.
Wife filed complaint.
Complaint.
You are the husband.
Yes, Lordship. No, I am for the other family member of the husband. Mother, brother.
Wife filed complaint for what?
My lord, as many as 3 cases. One is 498.
Let us see which one is the impugned.
My lord, seeking warrant and recovery of the gift article given by the.
Where is the
Yes, Lordship. Page, Lordship, 12.
page 12?
Husband is not before your Lordship. Other family member.
Majufa. Search warrant. Search warrant. Abdul Raqib, Rabia Khatun, Syed Abdul Malik. Who are the petitioners here?
My lord, 2, 3 and 4.
Rabia Khatun, Syed Abdul Malik.
And Aisha Khatun.
Okay, who are they?
My lord, Rabia Khatun is the mother. Mother
So,
of the
mother-in-law.
mother-in-law. And Syed Abdul Malik, he is the brother-in-law.
Brother-in-law.
And number 3, Aisha Khatun, sister-in-law. My wife of Abdul Malik, Syed Abdul Malik.
Okay, wife.
my lord.
The lordship may kindly.
This is what is 223 BNSS, I don't know.
My lord, 220
Cannot recollect, very difficult for me.
My lord, 223 is the BNSS, that is.
What is that?
Complaints, my lord.
Complaint file, oh, that one.
That one, my lord.
Okay. Then 227, what is that?
227, lordship, that is.
BNSS. Oh, very difficult. 220, 227. What is that? 227 BNSS discharge.
My lord.
Hmm?
And 97,
Issue of process, my lord.
What is 97?
97 is the lordship search warrant
Hmm.
against the stolen property or objectionable good.
I think a Stedon kind of thing or what? Or this four-wheeler. But I am not
Stolen property.
basically Stedon kind of thing.
Yes, my lord.
Huh.
Page 16 is the prayer.
Be kind enough to admit it, whether please to issue someone against the team and six hold him guilty. Issue source warrants.
I can do it.
Basically, it is a recovery.
Yes, basically recovery.
Hmm.
And in
Let's
this,
see, 406 kind of thing or what? 316.
in this case, lordship, this present petitioner has no role to play. It will be against the husband.
You are a resident of same house.
Well, under Pukraza district and case is filed in Dhubri.
Huh?
She is belonging to Dhubri.
No. You all are residents of the same house as like Abdul Rakib, her husband.
Well, they are lordship by my instruction, they are living separately.
So what happened after complaint?
My lord, the note,
Registered as what? Registered as?
my lord, register page, your lordship will find it. Page 18.
Huh?
Reference
Case number 179.
Case number 179. This is the summon issued by the magistrate.
Page
18. 18.
18.
My lord.
18 ABC.
My lord.
Same thing as page 11.
Same thing.
Same thing.
Same thing is page 11. lordship.
Now, have you gone through the provisions of 223?
Regarding,
BNSS. I think
regarding cognizance.
BNSS 223.
223.
First proviso. So that Mr. Khan should not come to this court invoking 482.
Fine.
Right? This provision has been
Loss.
incorporated in BNSS.
Provided that no cognizance of others shall be taken by them without giving a question opportunity of being heard.
So this is the opportunity given to you that you come to this court and say why this complaint is not maintainable against you. Have you understood?
Yes, I have understood.
So that otherwise so many 482 petitions. That is why Parliament thought it fit to incorporate this provision.
Loss. That is the intention.
Right. So that people don't rush to the High Court spending money. It can approach the trial court, which is near to it, and say every opportunity being heard, so that this complaint is not maintainable against you, me, and
Yes, lordship.
leave it to me. So thereafter, if the court takes cognizance,
Right.
cognizance will not be taken before you being heard. Thereafter, if courts will apply, hear both sides, then we'll take cognizance or will not take cognizance. So if cognizance is taken, then you are asked to this court under 528.
May I, Your Lordship, let it close with an observation that.
Because the counsel as well as the clients, both will be heard.
Lordship. Lordship may dispose of with that.
So with the observation that you will avail of, exhaust the remedy under the first proviso,
Lordship, I have understood.
right, at first. All right. At this stage, we will close this. After you are aggrieved, then you
Yes, then
heard Mr. M. Khan, learned counsel for the petitioner, and Mr. MP Goswami, learned additional public prosecutor for the respondent state. Full stop. The instant petition, criminal petition under section 528, Bharatiya Nagorik Surakha Sanhita 2023 is preferred by the three petitioners after receipt of a summon, after receipt of a notice to appear in person or through duly engaged counsel before the court of learned additional chief judicial magistrate Dhubri in connection with case number 179/2025, instituted by one Mafuza Begum before the said court. Post of para. After hearing the learned counsel for the parties at some length, Mr. Khan, learned counsel appearing for the petitioner, has submitted that the petitioner's herein would like to exhaust the remedy provided under the first proviso to subsection 1 of section 223 of the BNSS at first. Before invoking other remedies, before resorting to other remedies available under the law. Full stop. In view of such submission made by Mr. Khan and counsel for the petitioners, this criminal petition is closed, reserving the liberty to the petitioners to approach the court of learned additional chief judicial magistrate at Dhubri for under the availing the opportunity of hearing provided under the first proviso to subsection 1 of section 223 of the BNSS. So I am closing it, giving the liberty.
Item 13. May it please, Your Lordship.
Yes, Mr. Hussain.
My lord, NBW.
What happened?
Only 2 days, Lordship. I could not appear. 2 dates. I could not appear.
Dates. 2 dates.
Lordship.
According to Mr. Hussain, which dates?
Page 27, Lordship.
27, 7, 4,
This
31, 5.
Yes, this is a first.
Why it was ordered? You are Afjal Mandal.
Lordship.
You are seated where?
Lordship, may kindly see. SARS was framed on 55.
Oh, earlier you appeared.
Earlier I was appearing. Lordship.
Okay, what is the reason?
Lordship,
Or your non-appearance?
the case is pending since 2018.
You got bored.
We are all along we are appearing, Lordship, but I am a labor, Lordship. I went out for earning livelihood.
So your counsel did not take steps.
That is the reason, Lordship.
Okay.
Only 2 days.
Yes.
Lordship, Amanpreet, that judgments are there. Amanpreet and Siddharth.
Huh?
2 judgments, my lord.
Huh.
I have said.
Heard Mr. M. Hussain, learned counsel for the
Am I?
petitioner. M. Hussain. Am I?
Lordship.
M.I. Hussain, learned counsel for the petitioner, and Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, State of Assam. Full stop. The instant criminal petition under 528 B and SS is preferred, setting aside and or quashing of an order or quashing of orders, dated 7/4/2025 and dated 31/5/2025, passed by the Court of Learned Session Judge.
Additional sessions
Uh,
are FTC not some.
Okay, passed by the Court of Learned Additional Session Judge within bracket FTC, not Salman at Obhayapuri Trial Court. In the course of proceedings of sessions, case number 100 within bracket capital A of 2017. Post stop. It has emerged from the materials on record that on 19/12/2025, one Major Vikrant Sharma lodged the first information report before the officer in charge of Vayapur Police Station, alleging inter alia that a vehicle bearing registration number page 9 AS01/BK-4743 was intercepted on the suspicion that there were militants inside it. Post stop. During checking, one pistol with 3 live rounds and one revolver with 1 live round of ammunition were recovered, apart from 5 number of mobile phones. Full stop. The petitioners, 4 number of accused persons, including the present petitioner, were apprehended on the suspicion that they were militants belonging to MTFA. What is this MTFA? Full stop. The vehicle wherein they were proceeding was also intercepted. Full stop. On the basis of the said FIR, the officer in charge of Obhayapur Police Station registered a case, Obhayapur Police Station, case number 368/2015, under sections 25 within bracket 1-A of the Arms Act. Only Arms Act.
Lordship.
Full stop. Para. After completion of investigation, the IO of the case submitted a charge sheet by charge sheet number 63/2016 on 29/5/2016 against all the 4 accused persons who were apprehended on at the time of who were apprehended on 19/12/2015, finding sufficient materials for committing them to trial to face a charge under section 25(1)(a) of the Arms Act. Full stop. After submission of the charge sheet, the case has been registered as Sessions case number 100A/2017 before the Court of Sessions Judge Bongaigaon on 15/5/2018, a charge under section 25(1)(a) of the Arms Act was framed against the accused persons, including the petitioner. When the charge was read over and explained to the accused persons, they pleaded not guilty and claimed to be tried. As a result, the trial, the case proceeded to the trial stage. It is the petitioner has stated that in the subsequent stage, the petitioner appeared in the proceedings of session case number so-and-so through his engaged counsel. However, on 2 occasions, that is on 7/4/2025 and 31/5/2025, the petitioner could not be present in person before the trial court. It is further submitted that due to miscommunication, his petitioner's engaged counsel also did not appear on those dates. As a result, the trial court recording the absence of the petitioner in the proceedings, has ordered for issuance of non-bailable warrants of arrest. Full stop. The petitioner has submitted, has undertaken that he is ready and willing to participate in the further proceedings of so-and-so case number. When is the next date?
28/8/25.
Okay. Again, 15 days or time till 28/8/2025 করে দিব। Huh?
Till then, my.
Till then,
But
events and be dealt with.
Item number 14.
Criminal.
Rajendra Prasad Sharma, yes.
Criminal petition for quashing.
Quashing.
Quashing it.
What kind
Complaint
of
case,
quashing? What is the complaint? What is the complaint?
Complaint, page 11.
Complaint case or FIR?
Complaint case, page 11. Lord.
Meenakshi Devi,
Yes.
Rajendra Prasad, Rajesh Sharma, Nilima, Pinky, Kanti.
Land,
How you are related with Meenakshi Devi?
land dispute matter.
Okay, let us read the complaint.
Regarding 2 quota of lands, 4 cases pending. Let's go for court.
But what is the complaint? Let us see the allegation.
Allegation against the petitioner is that
Any particular incident?
that's it.
Yes, from delivery entered our premises, beat up my sick sister while she was feeding the chickens. I injured her whole body. I was informed of the incident by my sister on the phone and I immediately came home from school. When I got home, I found my sister was crying injured. My sister told me that the accused had been in civil case. Tied with ropes, beat me again. Okay, well, but Mr. Gogoi, yes, in spite of the pendency of civil suit, there is a specific mention of an incident 21/6/2024, beating and injuring the informant and her sister. And she also mentioned that it is Devani Gusar Bisarin hoye ase. Hal সম্পর্ক নাই.
4 cases pending. To
Okay. But this is an incident. How can we? Allegations are made out. It has been what?
That is right, Lordship.
It has been what? Registered? Registered? Huh?
Complaint cases already trial start, Lordship.
How? Cognizance has been taken.
Lordship. Now it is the appearance test. My case, Lordship.
Yes, Mr. Kosik, though it is not urged. Though no, it is not urged. It seems from the order
My lord.
there is violation of the
Yes.
provision.
Yes, my lord. The that's 223
Huh?
is provided.
Also recorded.
He has examined the witnesses
Uh-huh.
on behalf of the complainant, but the accused side is silent, my lord.
Did you appear?
No,
Did you receive any summon?
Lordship.
Huh?
Receive someone. It is a appearance test, Lordship.
Mr. Gogoi,
Order sheet, Lordship, is 38.
no, you are not getting my point. Problem is that.
Main, Lordship,
Please make him understand. No, please make him understand whether prior to 21/5/2025, whether they had received any notice and whether they had appeared before the trial. Okay, Mr. Gogoi, you come back after reading thoroughly
Lordship.
and after having full instruction.
Only someone's lawsuit. That is the.
After having full instruction from your client, nowadays the procedure of lodging a complaint has been changed. So go through it and come back
The date of.
on Monday or Tuesday.
223. Plus, sir.
Okay, on the prayer of Mr. L. Gugoi, and the council board of petition, I release the case on Tuesday. You come back during the vacation of Independence Day.
Tuesday, let's say. 19 years old.
Item 15.
Because that is an aberration, that is an infirmity, if notice was not put.
It seems when that steps has been perhaps when going by the order, my lord. That second steps has been not followed, my
It has been bypassed.
bypass.
Yes.
Please, your lordship, my lord, here in this case, lordship, petition number 1, 2, 3, where the lordship in charge district agriculture officer, lordship, Mazur.
Huh?
And
1, 2, 3.
1, 2, 3, lordship.
Who are they?
They already retired from the service, lordship, in the capacity of in charge district agriculture officer. of
In
Mazur.
charge district agriculture officer. Okay.
Mazur, lordship. Lordship, what has happened, lordship? There is a lordship scheme was launched, lordship, by the government of Assam, lordship, whereby the scheme was namely, lordship, Majuli as organic hub. To convert
Majuli?
Majuli as organic hub.
Who is this man? This is a complaint, page 39.
Yes, lord.
Hmm?
Yes, lord. Page 39 is the.
1 minute, 1 minute.
Here also same
Same thing.
thing.
Same thing, lordship.
Page 48.
220, no.
Now you make him file an affidavit, additional affidavit that before so and so,
Yes.
you were not, you do not receive any notice.
Here cognizance has been taken
Lordship,
already.
perhaps I can.
Then we will interfere.
Yes, my
We will interfere with this order, right? So but you find out, make him understand.
I have already.
affidavit.
You have understood.
Yes, lordship, because the notice is.
Is there any averment?
Lordship, in the time of drafting, lordship. I have
That
notes.
environment is not here, my lord.
If there is averment, I will proceed. By simply issuing notice.
Not here.
Lordship, I have annexed the lordship that.
Mr. Borbuya, if there is averment, I'll stay the proceeding. If there is no averment, I'll issue notice, making it returnable 4 weeks.
Lordship, I will file the affidavit. On 19th, lordship, the lordship may kindly.
Okay, under prayer of Mr. So-and-so, please the case on 19.
File.
For admission, item number 16.
Yes,
May I please, ma'am? This is an appeal preferred again.
you are fond of turtles.
Yes, ma'am.
Okay. Will issue, admit. And how much? 7 years.
7 years, my lord.
Will issue notice.
My lord, your lordship, may kindly see for the time being, my lord, only one sentence.
It was in possession or what?
Yeah, that's why, my lord,
Possession.
with regard to the position, my lord, page 20, my lord. PW4, who, my lord, searched and seized the turtles.
Page 21,
Yes.
okay.
Page 20, my lord, 20. This is, my lord, is this.
20.
Yes, 20. The Raju Das is the, my lord, appellant. PW3, the lordship will find. from
20,
the
page
third line.
20.
Yes.
Paragraph?
Paragraph, my lord, this is paragraph 11 of the judgment, my lord.
11. That is at 19 then, it starts at
Yeah,
19.
It starts from 19, my lord.
Huh.
Bakul-
PWC Bokul
Yes,
Gulja.
Bakul Kulta. He was the, my lord, seizure witness. He is the only person who, my lord, witnesses the seizure and deposed before the court, my lord. In his evidence testified that he was working as Councilor of so-and-so village under so-and-so, PM police and accompanying house of Raju Das. PW3 deposed that accordingly, along with police official, he went to inside the house of Raju Das, but at that time, Raju Das was not available in the house. So he is the only seizure witness, my lord, who witnesses deposed before the court.
And police
Would have been
investigating officials.
sir, he is the PW4 madam.
So
she's-
she's a balancing act. So we have to-
Contradicting themselves. He, madam.
But also police officers cannot be disbelieved outright.
My lord, he's informant, my lord. He's the informant,
Who?
PW4. He's informant as well as, my lord.
But it is the house of Rajudas, my lord.
Yes. In fact,
Though he is not
no.
at the
Your
home
Lordship
at that
will find
time.
PW4, what the PW4 has says, my lord. Your lordship will find it para 12, my lord. PW4, let us read just 2-3 lines, my lord. The evidence testified on 4/6/20 has first SI Joysagor OC. Then received secret information that turtles being available in the house of Rajudas, son of Kogendas, PW4 deposed that on the direction of IC, he along with police officer proceed to house of Kogendas. In fact, it is the house of Kogendas, my lord. PW4 deposed that he also some independent witness with him. And
Okay,
independent witness-
let LCR come. Heard Mr. J. Pine, learned counsel for the accused appellant, and Mr. B. Sharma, learned special
Special PP, my lord.
PP, public
Wildlife.
prosecutor, wildlife. Was the
Mike.
response number?
Response
One.
number,
What?
This information is required.
Informant is a government servant, my lord.
informant is he's an informant.
What
Forest-
were the respondents then?
My lord, both the,
Yes.
Same thing, his presence, absence does not
my lord.
make any sense. Okay, this criminal appeal is directed against a judgment and order dated 21/7/2025 passed by the Court of Additional
Additional
Session Judge FTC cum Special Judge Sivohagor within the Special Court. In Special WL case number 01 of 2022, which arose out of case number SIV লিখা আছে. By the judgment and order dated so and so, the accused appellant has been convicted for the offense under section 51 of the Wildlife Protection Act, and he has been sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 50,000, in default of payment of fine, to undergo simple imprisonment for another year. Full stop. I've gone through the grounds urged in the memo of appeal. The criminal appeal is admitted for hearing. Case records of so and so be called for. Issue notice returnable in so and so as Mr. Sharma, Special PP Wildlife, has appeared accepted. Notice on behalf of both the respondents. Issuance of formal notice, dispense with 1 copy, extra 1 copy. Heard Mr. So and so, applicant appellant, opposite party, the respondents. The instant application under section 432 BNSS is preferred by the applicant appellant seeking suspension of execution of the sentence passed against him and for his release on bail. Full stop. Issue notice returnable. Okay, both they did you. They did you. Returnable on returnable on so and so. As Mr. Sharma for both the opposite parties. Formal notice dispense with one extra copy, 2 working days. It's an application will be considered after receipt of the TCR. The respondents, opposite parties may file their objection to the instant application on or before the return will date, if so advised.
Okay.
17. May please, bill against conviction lordships. The appellant was convicted under section 350.
How much?
1 year lordships.
1 year.
1 year.
Yes, Mr. Kaushik. I heard Mr. P. Dotto, learned counsel for the, how many appellants?
1 lords.
For the accused appellant and Mr. R. Kaushik state. Page number 15 what was it?
31 lordships.
13/6/2025, additional session judge, Golaghat trial court, sessions case number 98 of 2019. Yes, Mr. Kaushik, for these offenses, whether practice direction is to be followed or not?
My lord.
Conduct offense
54-1.
by the judgment and order earlier favorable to you?
Yes, Lordship. Gold,
Gold.
yes, Lordship. Because
And the allegation is that
related.
gold
Yes, Lordship.
you purchased in
Yes.
exchange of 22,07,000,
Yes.
right? Or whatever money.
Yes, Lordship.
Now, you cannot have the cake and eat it too. Meaning thereby, you paid the price to somebody else. You got the gold. Now you are in possession of the gold.
Lordship,
It will be a case of double enrichment.
Lordship, I had submitted all the documents
Whatever.
related to gold.
Whatever.
That's why.
Whatever.
Yes, Lordship. And related cash.
Because
Lordship.
you are in possession of interim custody of the gold.
Yes, Lordship. And I'm paying for the cash.
No, paying from the case. Now you are holding one. You cannot have the gold and the money.
Lordship, I am relying
Right.
on some judgment. Lordship.
No, there is provision to keep it in bank lockers.
Lordship,
Because you cannot be unjustly enriched. Mr. Kosik, look at it this angle. His story is that I collected this much money to purchase gold. Is it not?
No, no, no. No, no, that's not the case, Lordship.
Huh.
Lordship, actually,
Let us see the earlier order.
earlier order. Lordship, kindly see,
What is the story?
Annexer 15, Lordship.
What is
page
the
number
story?
65. Page number 65, Lordship.
No, let us see the story.
FIR
Your
is-
story
FIR is on page number 19.
or their story.
FIR is on page number 19.
Huh?
Lordship.
Huh. Huh. Come to page 21.
Lordship, may I read? Lordship?
We found him engaged in melting the just spangled gold bars,
Yes, Lordship.
right?
Yes,
And on weight 585 gram,
yes, Lordship.
right?
Yes.
It was seized.
Yes, Lord.
And from that Himanshu, the
Cash,
currency
cash,
notes are seized,
cash, cash.
right? And the story is that
Lordship, cash is mine, Lordship. I have given to him to deposit the same to bank, Lordship. For purchasing a gold testing machine, Lordship.
okay. And what about the gold? What about the gold?
Gold is mine, Lordship. And I have submitted the documents, all the documents, Lordship, related to gold. Lord. It was
Okay.
passed.
Report.
Report we have not received.
We'll examine
Silent.
the issue, whether he is really entitled, because that these documents will examine. If we satisfied with your documents that you are the owner of the gold, you have correctly accounted for, we'll give you the custody. Otherwise, there is provision for keeping it in bank lockers also
Yes, Lordship. I have
for
submitted
safe custody,
I have
right?
submitted
Both
all
the
the-
options.
all the documents.
But
Lordship.
money, currency should not be kept at the police station.
Yes, Lord.
Okay, when?
My lord,
We'll issue notice making it returnable. It is no point keeping it hard. Mr.
H. Rahman.
Short date
Short date.
and Mr. R.R. Kosik. Mr. Kosik has, okay, already submitted, already issued.
issued only.
Mr. Kosik, Land Edition, Public Prosecutor has sought one last opportunity of 10 days
My lord,
to produce, to obtain the report as called for. Please the case on sense.
on 26.
Item 20. Item 24 orders.
Maybe the Lordship. Service awaited, Lordship. Service.
Yes, Mr. Sharma. Why you have allowed the court to issue notice? You are a party to it. Yes, Mr. Counsel. Why 447 power is to be exercised in such a case?
Transfer, Lordship.
Huh?
Transfer.
What is your case before the trial court?
Bongaigaon
Where you filed?
District Court, Bongaigaon,
District,
for divorce.
there are two things. One is session judge
Session.
and district judge.
District and session.
District and session judge.
Yes, Lord.
But his functions are different. Now, before whom you filed?
District and session, Judge, Lordship.
In which jurisdiction? As a district judge or session judge?
Local jurisdiction.
What is the case? You filed what case? Seeking what relief?
Page number 16 in the Court of
Seeking what relief?
District Judge, Lordship.
Seeking what relief? What do you want from district judge? Tell me. Or whoever has filed, what is the relief?
District Judge filed by the Lordship.
Mr. Sharma. Title suit divorce.
My lord.
Huh?
District judge.
So, what business B and SS have? Huh? It is not a criminal proceeding.
What?
Then,
The district judge. They will.
why have allowed? That is why my first question is, why you have allowed the court to issue notice? Hmm? You are the counselor or some leading counsel is there?
The petitioner, Lordship.
Huh?
Petitioner, Lordship.
Huh?
Petitioner, I am.
No, you are the
No,
leading counsel.
Yes.
Huh? Okay, 447. This I have to dismiss. Not to be entertained.
447 business for transfer of.
You invoke section 24 or 25 of CPC.
Criminal area to 9.
Have you understood? Is there any element of criminality in a petition for dissolution of marriage? For desertion?
Lordship.
No points. I'll pass the order now. Who has filed a petition?
Smriti.
Huh? Husband. Husband.
কোন হয়? Petition কোনে করেছে এটা?
Petitioner
Husband?
is the wife, Lordship.
And in the,
Husband is the respondent.
okay, heard, Mr. Mr.
Islam, Lordship.
A. Islam. Learned Counsel for the petitioner, Mr. B. Sharma, learned additional public prosecutor for the respondent number 1, comma, State of Assam. Post of the instant petition is preferred under section 447 of the Bharatiya Nagarik Suraksha Sanhita, seeking transfer of the proceedings of TS within bracket D, case number 40 of 2020, comma, which is presently pending before the Court of Learned District Judge Bongaigaon, comma, to the Court of to the Learned Family Court at Dhubri. Post of para. A copy of the petition filed in connection with TSD number 40/2020 is found annexed with this petition as annexer
1.
1. Post up from on perusal of the plaint petition, said petition, comma, it is found that the petitioner herein has been arrayed as the sole respondent, wherein the petitioner is one Sri Siddhartha Mitra, comma, who has been made the respondent number, who has been implemented as respondent number 2 in the Eastern petition. Full stop. Para. The petition in TSD 40/2020 is preferred by the petitioner Siddhartha Mitra under section 13(1) within bracket small 1a of the Hindu Marriage Act, seeking resolution of his marriage with the respondent therein, comma, which was solemnized on 13/3/2019, comma, on the ground of cruelty. Another full stop. Full stop. Para. The powers section 447 of the BNSS has provided for the power of High Court to transfer cases and appeals. And it reads as under. Not like first. The such power of transfer is specifically limited to criminal proceedings. Full stop. Para. The proceedings of TSD case number 40/2020 is evidently civil in nature. Full stop. The petition is therefore has to resort to the remedy available under the Code of Civil Procedure 1908. Full stop. The instant petition is therefore found to be in instant petition seeking to invoke the powers under section 447 is therefore found to be misconceived. Full stop. The same is accordingly dismissed, reserving the liberty to the petitioner to resort to appropriate remedy.
22.
Yes, Mr. Mukherjee.
The IA is filed for suspension of the NBWA, Your Lordship, check bounce case.
Check bounce
The
case.
fine is of 9 lakh.
What happened? Criminal revision petition.
Notice was issued, Your Lordship.
Issue notice.
My colleague perhaps
Why?
did not impress upon the court on the prayer of.
It is simple trial. The
Lordship,
proceeding is at the trial stage.
is conviction, Your Lordship,
Conviction.
conviction.
Let us see what happens. Let us see the main
Lordship,
petition.
in petition page number 12 to 41 is the judgment of the trial court.
12. Let us see. 12. Okay, this is additional CGM.
Thereafter, an appeal.
Commencement, 1 minute. Let us see the operative part. What is the check amount?
Check amount was 8,70,000.
Okay.
Fine of 12 lakh was imposed, Your Lordship.
Argument,
Is at page 38 is the.
page 30. 38.
Paragraph
12 lakh.
12 lakh was the fine.
No sentence.
No sentence. And default
Good.
stipulation was there, 6 months in default.
Huh.
Thereafter, appeal was preferred by me, Your Lordship.
Dismissed.
Appeal was, the
Dismissed.
fine was reduced, Your Lordship.
How much? 9,000. 9 lakh.
lakhs.
So natural consequence is
Default
Ah.
stipulation was there, Your
Ah.
Lordship. No direct
you,
sentence.
you're not paying anything.
I preferred this
So you have
revision.
to undergo default.
Yes, Your Lordship. Then
And if you have to admit, we'll invoke section 148. 9 lakh means 20%,
20%, Lordship, we may pay some amount, Your Lordship.
no minimum.
Because
Minimum is 20.
Lordship,
What is your rare and exceptional case?
Lordship, rare and exceptional case is that, Lordship, this person has in fact borrowed 4 lakhs rupees. Your
You are male or female? Jamuna Rai.
Female.
Hmm. What did you do for?
I am a professor, Your Lordship.
Ah, good. That day I remember. So your reputation will be harmed. You are an assistant professor.
Assistant.
Don't have the capacity
Capacity is there, Your
to
Lordship.
avoid imprisonment.
Lordship, reasonable amount.
180, that is the only law.
Lordship,
And you are absolutely out of the bracket. Mr. Kosik, an assistant professor. 1 month salary. Less than 1 month. We don't have any discretion also.
Lordship, discretion.
Discretion, no, morning I have exercised the discretion because sentence was 6 months and in default was 3 months, total 9 months. The lady had spent 7 months. So I had exercised the discretion. But you are not in the same category. You are an assistant professor capable of paying.
Only thing that 20%
20.
may.
Before the registry, I'm not giving it to the. If it, then I would start hearing.
Lordship.
I heard Mr. B.J. Mukherjee. Thereafter, we can put it into mediation also.
Lordship.
Yes.
Within how much? So that mediation, because lots of cases have been settled in mediation. So we'll put it on returnable within 30 days you can pay.
45 days. 45 days.
Then the period of this nationwide drive will be over.
Within 30 days, I'll trade.
You pay it. Thereafter we'll observe. That petitioner also wants to avail the process of mediation. Heard Mr. B.J. Mukherjee, Learned Counsel Porter. Petitioner. Revision petitioner and Mr. Naik. The instance revision petition under section so-and-so, read with section so-and-so of the Bharatiya Nagorik so-and-so is preferred against the judgment and order dated 8/4/2025 passed in NIC, sorry. 16/6/2025 passed by the Court of Learned Session Judge Sirang at Kajalgaon Appellate Court in criminal appeal case number 20 of 2025, whereby the Appellate Court while dismissing the appeal preferred by the revision petitioner herein, has affirmed the judgment, affirmed a judgment, an order dated 8/4/2025, passed by the Court of Learned Additional Chief Judicial Magistrate Chirang, Kajalgaon Trial Court, in an ICR case number 13 of 2022. Full stop. The proceedings of NICR case number 13 of 2022, also in again, by the judgment and order, partly allowing, while partly allowing the appeal, has while upholding the conviction of the revision petitioner under section 138 of the Negotiable Instrument Act, has reduced the sentence of fine amount, full stop, next prayer লিখো, the trial court had trial court after holding the revision petitioner guilty of the offense under section 138 of the Negotiable Instrument Act, sentenced the revision petitioner to pay an amount of rupees 12 lakh as fine to the complainant, and in default of payment of fine, to undergo simple imprisonment for 6 months. Full stop. The appellate court has, while affirming the conviction, has interfered with the sentence for payment of fine of rupees 12 lakh by reducing it to 9 lakh. Without interfering with the default stipulation. Full stop. Para. You have IA? IA for what?
For suspension of this NBW.
Okay. I'll pass it order in IA. The revision petition লিখক, the revision petition. I have gone through the grounds urged in the revision petition. The revision petition is admitted for hearing, subject to compliance of the conditions set forth in the order passed today in the accompanying interlocutory application IA criminal number 820/2025. The case records of so-and-so case number, so-and-so be called for, issue notice, returnable in 4 weeks. You were there?
Only the
Formal party?
complainant is
Only complaint.
only complainant.
The revision petitioner shall take steps for service of notice upon the respondent by registered post with AD. Para. Okay, it will লিখো। বাইখিনি থাকিল না? The instant interlocutory application is preferred seeking suspension of execution of the sentence passed against the revision petitioner and for her release on bail. Post of. তাৰপিছতে revision petition গোটেইখিনি লিখি দিব। The petitioner has averred that subsequent to disposal of, the appellate court, while disposing of the criminal appeal, had directed the petitioner to surrender before the trial court to serve out the sentence. While recording that no money has been paid to the complainant by the petition during the pendency of the appeal. Full stop. In deference to the judgment of the appellate court, the trial court had on 23/6/2000, right?
Yes.
23/6/2025, order for issuance of non-bailable warrant of arrest to the petitioner as the convict. Full stop. The applicant herein also sought interference with the said order dated 23/6/2025. Full stop. Para. The provisions contained in 148 of the Negotiable Instrument Act has provided the power of the appellate court to order payment pending appeal against conviction. Full stop, para. In this application, the petitioner has averred that she is an assistant professor of Birjora Koina Mahavidyalaya, Bongaigaon. And due to the NBWA issued against the trial by the trial court, the petitioner's reputation is harmed. Full stop. But having regard to it cannot be said. It is not possible to infer that the applicant does not have the means to pay in view of the position, in view of the career, in view of her career as an assistant professor. First of having regard to the provisions contained in Section 148 of the Act and the concurrent findings of fact recorded by the trial court and the appellate court, this court is considered view that the prayer for suspension of execution of the sentence passed against the applicant can be, a prayer for can be made subject to the deposit of 20% of the fine amount awarded as part of the sentence by the trial court and the appellate court. Also, therefore, it is ordered that subject to deposit of 20% of the fine amount award of rupees 9 lakh awarded by the trial court and the appellate court, that is 1,80,000 within a period of 30 days from today. No, it sentence. It is ordered that the sentence passed by the trial court and the appellate court shall remain in abeyance till the disposal of the accompanying revision petition, which has been admitted today for hearing, subject to deposit of so and so. It is further ordered that during the period of 30 days, which has been granted to the applicant to deposit the aforestated amount, the NBWA issued by the trial court by order dated 23/6/2025 shall remain in abeyance. The interlocutory application is disposed of with the aforesaid terms. Before the registry of this court.
For hearing, item 23.
Please, your lordship, kindly peruse the last order, Lord. 22/7.
As Dasgupta was going Yes,
Already lordship prepared lordship and.
prepared.
Lordship. That's day
Okay.
before yesterday lordship, they engage us lordship.
Huh?
Day before yesterday lordship, they engage us. So I need some time to compile all the lordship,
Okay. Submit a compilation
lordship may fix on Friday.
before the registry.
Lordship.
Friday or holiday, and all dates are booked. Friday is holiday perhaps.
Yes.
Someday else.
Then lordship may
Next
fix
week is
thereafter,
also
lordship.
covered, maybe thereafter. 28. Okay.
And lordship, my senior's
Mister?
name may be recorded, lord. My senior's name may be recorded.
Who is your senior?
HRA Chaudhary.
His senior is not required to be recorded. Actually, no senior's name is to be recorded in that.
Because
Cost
his
list.
name is not there,
Not
so
required.
there is some difficulty to find.
Not
his name.
required. Senior's name are to be deleted actually.
Lordship.
That is the rule.
Lordship. That's why perhaps,
Senior counsel's name are not to be.
perhaps, that's why, my lord, perhaps Wakalatnama, they don't sign
Yes,
things.
because he can appear in any case
Any case,
on any date
lordship.
and may not appear in the same case on the next date, provided material instructions are there. And Mr. I. Chaudhary,
HRA Chaudhary.
Land Council for the Appellants, he has Mr. Chaudhary has submitted that the process of translation is complete, and he would be in a position to submit the compilation within a week's time. He has thus sought for listing of the case appeal on a date after 1 week. Arakosi present. In view of the above submission made by Mr. Chaudhary, Learned Counsel appearing for the appellants, let the case be listed on 27/8/2025. Okay.
Deeply obliged.
Item 24.
In this case, my lord, last one, came as 2012 case, my lord.
Hmm?
This case has been filed, my lord.
Revision petition.
Yes. The revision petition, my lord, challenging the order, my lord, dated 7/2012. What happened in this case, my lord? Initially,
1 minute.
I lost the affair, my lord.
Huh?
From the department lost the affair for embezzlement of money. Accordingly, charge has been framed under section 409. And the accused approached before the learned session judge Diviga. The learned session judge Diviga, what happened? He converted section 409 to section 406. Against that, we have approached this court.
You are what? You are the accused or you are the complainant?
I am the complainant.
Huh.
I am the informant, my lord. The initial
See what has happened.
charge has been framed.
Very
under-
unfortunate in the sense that when 2013 notice was issued,
Yes,
right?
yes,
Proceedings under section 409 before the learned additional CGM,
yes,
Diviga will continue. This is the order,
yes.
409.
Oh, yeah.
Then thereafter, that was in 2013,
13.
right? That was exactly on 11/1/2013. But suddenly, on 21/3/2013, admit the revision petition. Interim order passed will continue until further order. What is the interim order?
That is not there, but
So proceeding stayed.
still, but
This is the
my instruction manual from the department. Rest to, I have been engaged in.
now who is the petitioner here? Let us see.
He is the liquidator at that time, a relevant portion. And the state fair man, that is the, that is
Right,
the
yes, that is
state,
right.
liquidator is state fair.
Huh?
Liquidator is state fair.
Let us see joint register, Binod Agarwal.
Yes, the relevant period matter, they can there.
Let us see the FIR.
Yes. Fair matter, that is page 12 matter,
Hmm?
page 12 matter. May I read, madam?
Hmm.
With reference to the subject stated above, I hereby inform Assam State Cooperative Marketing and Consumer Federation Limited, hereinafter referred to as State Fair for the sake of brevity, suffers substantial loss due to mismanagement and embezzlement of its fund. Finally, the Registered Cooperative Society Assam by notification number so-and-so 16/6/2016 cancelled the registration of State Fair. As a result thereof, the liquidator was appointed to look over took over the possession and of the assets of the State Fair for the purpose of liquidation of its claims and liabilities. At the relevant time, Sri Rambora branch manager State Fair, Sri Pawan Rajpua, sub-accountant, and Sri Pasanta Kumar Datta, sub-accountant, were posted at Dibrugarh branch of State Fair with their respective designation. After liquidation, Sri Pavitra Gogoi, Senior Inspector, Cooperative Society, Dibrugarh, was made custodian of the State Fair, Dibrugarh branch. However, in spite of repeated requests, Sri Rambora, the then branch manager of State Fair, Dibrugarh branch, did not hand over the complete charge of the branch to Pavitra Gogoi, Senior Inspector. Not to speak of them, by letter dated 9/3/2007, the Deputy Commissioner Dibrugarh directed the accused Sri Rambora to hand over within 3 days certain documents and registers relating to the branch to the custodian. But he defied, and the said direction with utmost arrogance. The matter was also taken up to the government level, but without any result. As such, the liquidator, by his letter dated 8/10/2007, instructed Sri Pavitra Gogoi, custodian of State Fair, Dibrugarh, to lodge FIR at police station against the accused Sri Rambora. Finally, Sri Pavitra Gogoi, custodian State Fair, Dibrugarh, succeeded in taking over possession of the entire document and registers pertaining to the Dibrugarh branch of State Fair on 11/9/2006 to 15/9/2006 from accused Sri Rambora branch manager. Thereafter, liquidator State Fair got audited the entire account of Dibrugarh branch of State Fair by 4 senior auditors of the government of Assam, Cooperation Department for the period 15/6/2006 to 31/3/2007. On such audit, it has come to the light that 3 accused persons, namely Sri Rambora ex branch manager Sri Pawan Rajpua, and sub-accountant, assistant sub-accountant, and Sri Pasanta Kumar Datta, ex sub-accountant, have misappropriated huge amount of money from Dibrugarh branch of the State Fair. From the audited balance sheet as well as audited observation notes signed by 4 auditors on 23/8/2007, it is revealed that accused Rambora ex branch manager State Fair, Dibrugarh branch, has misappropriated total amount of rupees 1,52,20,2,819.54 rupees only by way of showing fake payment under different heads. Similarly, accused Pawan Rajpua ex sub-accountant State Fair, Dibrugarh branch, also misappropriated a total amount of rupees 13,01,587.38 paisa only. And the fact of this misappropriation has come to light on the examination of the balance sheet of the period 2004-05. On further examination, the balance sheet of the period 2004-05, it is seen that an amount of rupees 54,85,703.60 paisa only has been misappropriated by Sri accused Prasanta Kumar Datta, who was posted in Dibrugarh branch. Apart from that, the balance sheet as on 14/6/2006, that is on the date of notification of cancelling registration of State Fair, shows the total amount of rupees 24,99,189.81 and 33 paisa only has been misappropriated by the said accused Prasanta Kumar Datta from cash balance. Sale proceeds, fake cash payment, sale proceeds of sugar as traveling allowance, advance, and fake payment of huge godown rent in cash. Thus, the accused Prasanta Kumar Datta misappropriated total amount of rupees 79,84,892 only from the Dibrugarh branch State Fair. But be it stated that these informant liquidator by letter dated 12/3/2008 individually asked all the 3 accused persons to refund the misappropriated amount by the said letter notice failed to invoke any evoke any response from the two accused, namely Ram Bora and Prashant Kumar Dutta, while accused Sri Pawan Rajpur tried to evade the liability by making irrelevant explanation while letter dated 29/4/2008 addressed to these informants. Since the informant was expecting positive response from the accused person to the said letters dated 12/3/2008, some delay has been occurred in lodging this affair. From the audited account of Dibrugarh Madhya State, it is prima facie established that all the above named persons have jointly and severally hatched conspiracy for dishonest misappropriation of public money for their wrongful personal gain, thereby have committed offense of criminal breach of trust. That is the case, ma'am.
And
My lord, in the meantime, my lord, I inform my lord, accused number 1 probably fired. Last time.
accused number 1, who is that accused?
Ram Bora, my lord.
Ram Bora.
Now, after that, my lord, page 15, my lord.
Ram Bora expired.
Yes,
Let us see the story.
yes,
Total story.
yes. After that, page 15, my lord.
Page 50?
15.
15.
Yes, 15. There is after the investigation, my lord, this charge has been framed, my lord. Accused-
409.
Yes, ma'am, page 15.
3 persons, right?
Yes, 3%. Rambara, Pawan Kumar, Rajkumar, Prashant Kumar Dutta are present. I have already had submission of both sides from the material prima facie under section 409 is made out against the accused person. And accordingly, charge under section 409 is framed against the accused person. And same is read over and explained to them, to which they pleaded not guilty and claimed to be tried. Accordingly, pronunciation. Then, my lord, they approached the learned session judge, and learned session judge at page 19, my lord.
That was not order challenged.
Yes, yes. Ultimately, to 409 has been altered to 406 by the order of the learned session judge.
Let us see this order, page 19.
Page 19. This revision petition is directed against order dated 23/4/2012 passed by the learned Chief Judicial Magistrate Dibrugarh, whereby charge under section 409 was framed against the accused. Brief fact of the case leading to the present revision petition. Yeah. An affair was lodged by one Bikanath liquidator stating therein that the accused Ram Bora branch manager Pawan Rajpur and Prashant Kumar Dutta, sub-accountant, who were posted at Dibrugarh Madhya State Fair, misappropriated huge amount, and upon such affair, police registered a case, and after completion of investigation, submitted charge sheet against Ram Bora, Prashant Kumar Dutta, Pawan Rajpur. Learned Chief Judicial Magistrate Dibrugarh took cognizance of finding prima facie case against the accused person, framed charge under section 409 IPC against all the 3 accused persons named in the charge sheet. Being agreed by the aforesaid impugned framing charge, the present revision petition has been filed. Instant revision petition. I have had the learned counsel for the revision petitioner as well as the learned TP. Learned counsel for revision of the revision petitioner has submitted the revision petitioner not being public servant charged under section 409 against the revision petitioner was not tenable and prayed for setting aside the impugned. I'll come later on, my lord, they are public. The revision petitioner and the other against whom the charge has been framed in the instant case were evidently employee of a state fair, being a state trading agency of a state government constituted under Assam Cooperative Societies Act and not a corporation. As such, the revision petitioner not a public servant. Contended by the learned counsel for the revision petitioner, a plain reading of section 21 of the IPC defining the expression of public servant shows that present revision petitioner is not a public servant. The revision petitioner also does not fall in other category of person, that is banker, merchant, factor, broker, or agent as mentioned in section 409 of the
Okay, it was ultimately trial court for framing charge.
Yes,
Remanded, I think.
yes, yes.
Remanded back.
Remanded back.
Thereafter, what happened?
Thereafter, my lord, this.
What observations? That 409.
My lord, that's the last one. My lord, your lordship may come to page, we can read it from my lord. Page 22, my lord. However,
However,
yes, from the second.
which part? However,
However, under what provision of law the accused shall be punished for commission of the breach of trust? It will depend upon the evidence adduced at the time of hearing. But what is pertinent to mention here that no order to constitute offence under section 409 of the measure of major ingredient is that person against whom charge of criminal breach of trust is brought must be a public servant, committing offence of the capacity of the public servant or by anyone one in course of business as a banker, merchant, factor, broker or agent as defined under section 409 of the IPC. Since present petitioner accused, the revision petition does not come within the definition of any of person, perhaps, and this is very important one. Learned could also not sure. Perhaps the charge under section 409 would not have been framed as one of the basic ingredients of the framing charge under section 409. Was absent in the instant case. May it be when from the record it appears that where prima facie case of presuming commission of the criminal breach of trust, learned benches ought not to have framed the charge under appropriate provision of penal code. Since the charge can be altered at any time before the pronouncement and judgment, mere defect in framing of charge or framing charge under inappropriate section of law cannot vitiate the entire proceeding. In the fact and circumstance of the present case, it appears to me that when there is a prima facie material, the accused presuming commission of the offence of criminal breach of trust, mere defect in framing charge under improper section would not affect the merit of the case. The above fact of the circumstance, I have the considered view that it is a fit case which should be sent back to the learned court for framing charge of criminal breach of trust under appropriate provision of law. That is the fact. No, my lord, if I take your lordship to section 21 of the IPC, my lord, I think we fall, my lord. They come. Then again, the provision did not mention, they did not mention the provision, probably 397, my lord, has been invoked.
you are representing whom?
I am representing the state federal.
State.
Liquidator.
State.
Yes.
So cognizance was taken under section 409.
Yes, 409. And that has been altered.
Charge was framed under 409.
409.
The appellate court did not interfere with it. Did the appellate court interfere?
My lord, the learned session judge. Yes, sir, that is the order, my lord, appropriate.
What? Which one? Page 22.
Yes, my lord.
Which part?
That 409, it is not a case of under section 409, my lord. That is the overall finding, my lord. Although it is not directly mentioned.
No, it is not there, neither here nor there.
Yes.
We should send back to the learned trial court for framing charge, meaning thereby impliedly
406.
set aside.
Yes.
See page 23.
Yes, page 23.
Send back to the trial court for framing charge
Yes.
of criminal breach of trust
Yes.
under the appropriate provision provided in the penal code.
Yes. Because earlier line, foregoing line indicate it won't be section 409.
406, right?
Yes, it will be 409.
Now let us see Indian penal code.
No, main issue, my lord, my learned session just.
Why you are aggrieved, basically?
Because the punishment under section 409 is because of the amount involved, my lord.
Now you are liquidator.
Yes. Because
All right.
after liquidation, my lord, all this, my lord, this is the duty of the liquidator, my lord, to dispose of and recover whatever is there, my lord. So when the liquidator is found, my lord, the state will found huge amount of money, my lord, in the process of liquidation, my lord. Huge amount of money has been swindled, my lord. Of course, the main accused, my lord, expired, my lord, chief secretary. That is, that's. And again, 397 probably learned session judge, although no mention section, my knowledge, my instruction that is under section 397, my lord, it has been altered, but 397 charges cannot be altered probably, my lord, because 397, my lord, clearly said, my lord, that the powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in appeal, inquiry, trial, or any other purpose. This one paragraph indicates, madam. That means framing of charges in interlocutory order. Number 5. That is one of my submission, madam.
Now, this revision petitioner is aggrieved by what? By this appellate order?
Yes, yes.
On what is this thing that 409 is impliedly
Yes, it should have been there. 409 cannot be changed.
removed? But the 409 is not affected, is mentioned here.
Yes, yes, yes. The learned session judge said the things. I'm not a public servant, but my lord, they are not a public servant. The accused are not a public servant. They cannot come under section 409. But again, section 21 also the learned sessions are discussed. But 21, I think the accused covers under section 21. They are public servant.
No, where are the accused? You represent the accused.
Actually, I'm appearing on behalf of M. Sharma, Lordship.
You, Sharma.
M. Sharma.
M. Sharma.
Lordship, he was there in the court today, but fell unwell and had to leave, Lordship. Lordship, we are for the respondent number 1, 2, and 3. Lordship, 1 had expired.
Yes, yes, 1 expired.
You are now interested in what, Mr. Jodi?
My lord.
That 409.
409.
409, let us see section 21.
Section 21, my lord. I'll read, my lord, it's a small one.
Hmm.
The IPC, section 21, the IPC public servant is discussed. The word public servant, your lordship got it, my lord. The word public servant denotes a person falling under any of the description herein after following. My lord. Every commission, second, every commission officer in the military, that is will not come. Third, every judge will not come, my lord. Fourth, every officer of a court will not come, my lord. Fifth, every jury master, my lord. Sixth, my lord, every arbiter or any other person who in any cause or matter has been referred to decision report, they will not come. Every person holds the office by virtue of empowered, my lord. Seventh, every person who holds any office by virtue of which he is empowered to place or keep any person in confinement. Then 8, every person, this is the government, whose duty is as such officer to prevent offence or to give information of offences, to bring offender to justice, or to protect public health, safety, convenience. 9, every officer whose duty officers to take, receive, keep, expend any property on behalf of the state, or to make any survey, assessment, contract on behalf of the government, or to execute any revenue process, or to investigate, report any matter affecting the pecuniary interest. To make, authenticate, keep any document relating to pecuniary interest, or to prevent infraction of any law. 10, every officer whose duty it is as such officer to make, receive, keep, or expend any property, to make any survey, assessment, or to levy any rate, tax, or any other secular common purpose of the village, town, district, or to make, authenticate, keep any document for ascertaining the rights of the people of the village and town. 11, every person who holds the office or any office in virtue of which he is empowered to prepare, publish, maintain, revise an electoral roll, or to conduct an electoral part of election. 12, in the service in the service or pay the government or remunerated by fees or commission for the performance of public duty by the government. In the service B, in the service or pay of a local authority, corporation established or under Central Provision Act, or state or government company defined under section 6, 17 of the Companies Act.
My lord, in this
None.
way, last but one,
None.
last but one, my lord, because I am,
Rajbat one, which one?
my lord. my
Which
is,
one?
Service to pay the government or the fees,
In the
commission.
service or pay of the government?
Public duty by the government, my lord.
Public duty by the government, not
Because,
government is government.
Because,
State
yes,
paid is state paid.
Yes, sir.
Completely different. Completely different. PCA.
here, my lord,
Under section 21,
yes,
as defined, provided in IPC,
yes,
is somewhat different
yes, from
to PC Act,
PC, yes,
right?
yes,
PC Act, you will find
yes.
say this one. Any person who is an office bearer or an employee of an educational, scientific, social, cultural, or other institution in whatever manner established, receiving or having received any financial assistance from the central government or any state government or local authority or other public authority, right? There is another one.
Here, my lord, we are salaried person.
This one. 9. Any person who is president, secretary, or other office bearers of a registered cooperative society engaged in agriculture, industry, trade, banking, having received financial aid from central government, state government, or from any corporation established by or under central, provincial, state, or any authority, body owned or controlled or aided by the government or a government company. This is one. Then society is also there somewhere. Somewhere society is also there in PC Act. Right. But society is missing in 21. I don't find anything.
Here again, my lord, because initially, my lord, we are
Anything. Now I'm thinking that whether this petition was not with proper motive.
It was filed way back, my lord. But here,
Because the revisional court or appellate court has changed it into perhaps interfered with 409.
yes,
Right.
interfered for journal.
That these 3 persons, Ram and all
Yes,
these, do not come within the definition of
Public,
public
yes.
servant. So 409, which is by public servant, would not be attracted.
would not be accepted. That is it.
And 406.
Yes,
Now, for what reason you are aggrieved?
because, my lord,
Because it is
whether after paying of the charge, by the
that is what now I am.
trial
Why
court,
a liquidator, once it is no, was it a police case?
my lord, yes, yes,
ZR case?
yes, yes,
Huh? ZR case.
Yes.
You are only informant or something like
yes,
that.
confirmed.
It is anything aggrieved is to be by the state government.
No, but it has gone to
Because
liquidation, my lord.
Huh?
It has gone to liquidation, so liquidator has,
Liquidator in what capacity?
because liquidator has been entrusted, my lord.
Locus is doubtful now.
My
Once it
petitioner,
is,
my lord, paragraph
you file it,
Yes,
the FIR, case is registered.
yes,
Thereafter, prosecution is taken over by the state,
yes, yes,
right?
yes.
You have no role. But yes,
Big informant.
being informant, you will be called as a witness. Right.
Yeah, my locus has been discussed.
But
probably in
when
the-
charge is framed,
Yes,
thereafter, you as an informant, let us assume.
yes,
But this Ram, Pavan, and Prasanto, they do not fall within the definition of 21. So, this appears to be misconceived. And indirectly, by prosecuting this, the entire trial is kept pending.
Yes.
Witnesses have lost memory, some have died, everything. The
Yes.
purpose is perhaps oblique,
That
looks
is-
like, because why liquidator has filed?
Because.
It should have been filed by public prosecutor to the state.
Yes.
You should have written to the state government that this is what has happened, if a really bona fide motive. But why this is 409 is not detected? Apparently from the, let us see this,
Paragraph number 1, my lord.
let us see the, what is statement.
Yes.
It is in the FIR itself.
Yes. Correct. Assam State Cooperative. Marketing
It is marketing consumer production. Since it means it is a cooperative society.
Cooperative. But liquidity is a government officer.
No, that not liquidator is not government. He acts in individual capacity.
Yes, of course, individual capacity, but being a government
Individual
officer.
capacity, but this is a society.
Society.
And because registered cooperative society cancelled the registration of state fed. Meaning that it is evidently a society, cooperative society.
Now cooperative society, but it is led by the liquidator. Man.
No, that is
The government is.
no. It has gone. It has defunct.
Yes, but government.
It has gone. It has become defunct.
Yes. Otherwise, yes. In other words,
Defunct.
yes. But
And even if they were public servants,
yes.
at the time at the time of commission of the offense,
Yes. Yes.
right? But after cancellation, they were no. But question is, any of this? Let me read. Public servants, military, judge. Liquidator is okay. He is public servant.
Yes, sir. Liquidator.
But he is not government.
He is not government, of course.
Assessor, panchayat. No. Arbitrator. Keep any person in confinement, no? Sixth, seventh. Eighth, no?
I mean, ninth will some way or other, my lord.
No. First, you are a society.
Yes.
And
After liquidation.
these are employees of a society, cooperative society. This Ram, Pavan and all, they are employees of cooperative society.
State fed, yes.
Yes.
State fed.
Now,
Branch of state fed description legal.
you do not do any public duty. Because
No,
public,
SS
public duty is with connection with sovereign function.
Yeah,
Not this state fare is for the purpose of earning profit.
No, but one thing, my lord.
No.
Once liquidator appointed for the
No.
of the assets, which are
Mr. Churi, you are confusing. 409 is framed against whom?
Oh, yes, public service.
Please,
Yes.
don't confuse.
Yes.
We are concerned with this Ram, Pavan and this thing.
Yes.
Don't confuse. Why you are projecting, still now you are projecting
No. 409 is all right.
as if
Public
you are
service.
protecting these three persons.
No, of course not, my lord, of course not. We actually, because this has been filed by lord.
It looks like,
To-
it is looking like that to the court. You forget whom you are defending.
Because I want 409, that is why the petition was filed.
Now, that is a different thing, my lord. The question is here only thing whether the learned session judge has rightly passed the order. That is the issue.
Don't look like it is correctly done. Section 21, what do you say? Yes, Mr. Counsel. What is the ground urge? What is the ground urge?
My lord. My lord, in my petition, my lord. Yes, my lord. Ground, my lord, the page 5, my lord. Page 5 from ground 2, my lord, I did, my lord. Learned session just paid to appreciate the material on record in his proper perspective, arrived at an erroneous decision to remand the case to the learned trial court with the direction to frame charge under section 406. For that, the learned session judge has committed material irregularity by directing the trial court to frame charge of criminal breach of trust in view of the fact that FIR Annex 1 as well as material so far collected by the investigating officer clearly discloses offences under section 409 of the Act. For the ground number 4, my lord, for that the learned trial court framed the charge under section 409, having satisfied after being heard, after hearing the parties and considering the material on record, that a prima facie case is made out under section 409 IPC by the prosecution. But the learned session judge Divigor exercised power not vested in him by directing the learned trial court to alter the charge. For that, the framing of charge is not final order, and in that view of the matter, the learned session judge ought not to have interfered with the order of framing of charge under section 409 of the IPC by the learned magistrate. For that, the finding of the learned session judge Divigor, but the accused opposite party does not come with the definition of public servant is a perverse one. For that, impugned judgment is perfectory inasmuch as the learned session judge held, perhaps charge under section 409 would not have been framed as one of the basic ingredients of section 409 was absent in the instant case. For that, the learned session judge misinterpreted the definition of public servant under section 21, and as such, the impugned judgment is illegal. For that, the relevant time of embezzlement in misappropriation of fund, the accused petitioner were functioning as branch manager of Dibrugarh branch of a state fed, while the other accused were posted as sub-accountant, and by virtue of their positioning state fed, it is safely presumed that they are running affair business of the state fed in the capacity of the agent of the society, and therefore learned trial court did not commit in framing the charge under section 409 against the accused. Sentence is wrong, my lord. Further, a learned session that Divigor held opposite party accused not to be public servant within the meaning of 21 of the IPC without discussing the service condition of the accused person, as the same is not not a finding based on record for which the impugned judgment is liable to be set aside. For that, the section 406 of the IPC stipulates lesser punishment than that of 409. And in the event of finding of the accused person to be public servant within meaning of section 21 of the IPC, the impugned judgment will stand in the way of convicting and sentencing the accused under section 409. 12. For that, whether or not the accused person or public servant has to be determined by adducing evidence by the prosecution and defense. But the learned session judge Debigar has jumped on to a conclusion that without any evidence on record to that effect. For that, the opposite party accused is not at all prejudiced due to framing of the charge under section 409. And even if it is presumed that opposite party cannot be charged under section 409, it appears that after closure of evidence in the event of learned trial court empowered under section 216 of the CRPC, as such interference caused by the impugned judgment is not tenable in the eye of law. The major share of the state fare is owned by the government of Assam, and functioning of the state fare is directly and indirectly controlled by
Major?
ground 12, my lord. For the major share of the state fare is owned by the government of Assam, and the function of the state fare is directly or indirectly controlled by the government of Assam. And it is the reason why the government of Assam released huge funds to the tune of several crores for implementing voluntary retirement scheme in a state fare before and after its closure. As such, under no stretch of imagination, the employees of a state fare can be said that they are not public servant within the meaning of section 21 of the Act. These are the grounds.
But still a society.
Yes, still a society, of course. That has to be admitted. Its name itself is society.
Then it'll be 1981, 3 SSC, 431. SS Dhanua. Followed Epsilon, Reliant, Admit. Okay, so then after tomorrow. I have understood your case. But it has been distinguished that corporation is different and corporation in 12B, corporation is different than society. That has been distinguished already.
Yes, yes, that is also that I.
So if the corporation does not fall within the ambit, then employees do not fall.
Do not follow.
Then employees do not fall, then it will not come under the purview of 409.
Is that? But actually, my point of argument, one more point of argument was, apart from this matter, that whether the learned session.
Mr. Now, in any view of the matter, because of your interference by this criminal revision petition, every witness is dead now.
Maybe, because of the one of the main.
0% chances of conviction now because of your interference by this criminal revision petition. Now, otherwise, the trial would have been complete and it would have been before appellate stage, thereafter revision before this court pending. But because of you or interference, this petition is still at the stage of appearance of the trial.
My lord, I was.
Meaning thereby, I am saying that
Yes, sir.
liquidator, I am not saying to you, you represent the liquidator,
Yes.
and because of your creation of this situation,
Yes.
they are having 100% chances of acquittal now.
That is-
You will not find the witnesses now for next 10 years. Even if I remand the matter.
In fact, when the matter was handed over to me, actually, I advised the
don't know.
department to withdraw the case.
I don't know, the
But
trial will
the-
continue under 409, it was then. Somehow, interestingly, interim order shall continue. What is this? Without any reason, everywhere, I am finding it. No reason for interim order. Okay, day after tomorrow,
Ma'am.
I'll pass the order. Now it is too tiring.
Yes,
Okay, hearing. Huh? Huh? Oh. Okay, okay. Are we like fix for us? Okay. How you Put it? Okay. Thursday.
ma'am.
A. Chaudhary and Mr.
Argument.
Arguha. Rambora died.
Lordship, yes, Rambora died and Lordship, respondent number 3 also died, Lordship.
Died.
Yes, Lordship.
See, the liquidator has done wonders for in the process of recovery of crores of rupees. You have done wonders. 2% died.
Lordship,
Right.
respondent number 2 may also have died, Lordship.
You get the instruction by tomorrow.
Lordship.
See the wonders. I was having a notion that he might have done it with some not bona fide, other than bona fide. I have been saying it
Yes,
2-3 times. Now he is saying 2% died out of 3 accused. Now third one may also die. Gone. With the wind, the money, crores, 10 crores or 3 crores of government money because of liquidator. And there is a proverb.